I'll call this regularly scheduled meeting of the Tennessee Real Estate Appraiser Commission to order. If we would, I would please like to have a roll call starting at my left and proceeding to the right. If you would state your name and where you're from, please.
Nancy Point, Rogersville.
Eric Collinsworth, Arrington.
Mark Johnstone, Jackson.
Tim Walton, Collierville.
Rosie Johnson, Paris.
Fred McCara, Johnson City.
That does constitute a quorum to conduct business. I believe Mr. Hall is here and will be stepping in shortly, and we'll note the record when he does arrive. This regularly scheduled commission meeting is taking place in room 1A of the Davy Crockett Tower, located at 500 James Robertson Parkway, Nashville, Tennessee. And the notice of this meeting was posted on the Tennessee Real Estate Appraiser Commission website. And today's date is August the 11th, and the time now is 10 a.m. We are ready for item 1 on the agenda, which is the adopting of the agenda. I would entertain a motion to adopt the agenda at this time.
I so move.
Second.
We have a motion from Commissioner Point, seconded by Commissioner Walton, for the adoption of the agenda. Is there any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? The agenda has been adopted for today's meeting. Review and approval of the July 2014 Commission meeting minutes. Those minutes have been distributed. Has everyone had an opportunity to review those minutes? At this time, I would entertain a motion to approve the minutes as distributed or as revised or amended, if that is necessary.
So moved.
To revise,
No,
amend,
to
or as
approve.
presented. We have a motion to adopt the minutes from the July 2014 Tennessee Real Estate Appraiser Commission meeting as presented from Commissioner McCara. Is there a second?
Second.
Seconded with Commissioner Point. Is there any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? July minutes are approved. Next item on the agenda is a formal hearing, and at this time, the court reporter is not here, and we have spoken with the administrative judge, and that is going to be postponed until approximately 10:30. So if it's okay with this body, we're going to continue on with board business until that point in time. So next item would be the legal report. At this time, I would ask Ms. Gamber to proceed.
Okay, if you guys are ready, this shouldn't take very long. So we'll start with item number 1, 2013-023-731. This complaint was filed according to a letter that was sent. Oh,
In your iPads, that's page 34, if you want to turn along with us.
sorry.
Sorry.
No, you're fine. This complaint was filed according to a letter that was sent by the FHA of HUD's removal with education sanction imposed against Respondent for violations of FHA guidelines and USPAP. Respondent sent a response to the complaint stating the issue has been concentrated on the subject's property acreage. HUD handbook specifically states, excess land is another area in which to exercise caution. Land is considered to be excess if it is larger than what is typical in the neighborhood and capable of a separate use. Data was provided to show that although predominant site size in the community is 1 acre or less, the typical size farm is comprised of 65 acres and the county population is 40% rural. As the subject size is typical for the neighborhood, it does not meet the first criteria for excess land. In addition, survey maps were provided showing a .34 portion that was sectioned off the front of the subject site on which a manufactured home occupied by a family member is located. Leaving sufficient road frontage for the subject property, there is little road frontage for access to the remaining acreage for any future development, limiting its capability for separate use. As the subject's property does not meet either of HUD's criteria for excess land, it is respondent's opinion that the subject's acreage is a readily marketable real estate entity with value. It's listed the reviewer's conclusions there. When you guys are finished looking over those, we can talk about the recommendation.
Apologize, there was a
Hi. I'm surprised I got here when I did.
Everyone had time to review the conclusions? Okay.
Respondent has been a certified residential appraiser for almost 10 years with corrective education as the only disciplinary action. As this matter has been addressed by the FHA corrective education and would only have merited a letter of instruction regarding the reviewer's conclusions noted above on its own, it is council's recommendation that this matter be closed with no further action.
Heard the reasoning and recommendation. Is there we have a motion?
So moved.
A motion from Commissioner Walton to accept the closure with no further action. Is there a second?
I'll second.
Seconded by Commissioner Collinsworth. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Okay, that issue is closed with no further action. We're ready for number 2, 2014007581.
Okay. Item number 2, this complaint was filed anonymously and alleged that respondent violated USPAP in a residential report that was performed on April 22nd, 2012. Such alleged violations included the neighborhood analysis, sales analysis, cost approach, and reconciliation. Respondent sent a response agreeing that he conducted the appraisal on April 22nd, 2012. Respondent stated that 9 verified closed sales on the subject street and less than a mile away were supportive of the predominant value of the immediate neighborhood. None of the closed home sales used in the report were identified as non-arm's length transactions by the courthouse records, and none of the sales listed showed the same seller. The report states in the reconciliation section that market data reflects the active market. Cost data is reliable, but more weight should be given to the market approach. The reviewer's conclusions are listed there, and the respondent also sent a response to those conclusions in this matter. So just take some time to review that, and then we'll be ready for the recommendation.
So everybody had an opportunity to review the findings, the conclusions, and the respondents' findings. Ms. Keeley?
Okay. The reviewer found multiple use PAP deficiencies within the appraisal report that warrant disciplinary action. The respondent currently has 3 open complaint matters. I said matters. I don't know what that is. I'm sorry. Matters alleging overvaluation, which are in the same development area. Due to the excessive nature of respondent's past disciplinary history, council recommends the authorization of a consent order for the voluntary surrender of respondent's credential. Such terms to be settled by consent order or formal hearing.
Heard council's reasoning and recommendation. Do we have a motion for any action?
I move we accept council's recommendation.
A motion for Commissioner Point to accept council's recommendation. Is there a second?
Second.
Second from Commissioner McCara. Is there any discussion? Not? Oh,
I do. I've got to say, the licensing history of this appraiser is concerning, but when I'm looking through some of the charges, I'm a little skeptical for this harsh type of discipline, and I'm a little on the fence.
thank you for that comment. Any other Comments?
I have a question too. You mentioned in here that there were 3 other open complaint matters. You may not be able to tell me, but are we going to be discussing these later today, or are these ones that are pending further action down the road, or?
We won't be discussing any more of those on this legal report today. There-
One is already authorized for formal hearing. The other one is, still has to be reviewed. But they're all 3 related in the same subdivision.
So what we have right now with regards to open cases is the one that we're discussing right now, that the motion is on the floor of concerning. There's one that's already been authorized for a formal hearing that's pending, that hasn't been come before this body. And there's another one that's open that has, it's in the review process and hasn't made it to the legal report at this time. And then the licensing history dates back to 93, if that's right. If that's what the initial number is on there, we've got 93, 94, 94, 94, 94, 2005, 2005, 2010, 2010, and then 3 more. So that's the history. And along with some suspensions that have been sprinkled in there. Any further discussion? If not, all in favor of the motion on the floor signify by saying aye.
Aye.
Aye. Any opposed? None opposed? Unanimous? We're ready for item 3. That's 2014-0122221.
Yes. This complaint was filed by a consumer and alleged the undervaluing of a residential property by using inaccurate comparable sales data. Respondent sent a response to the complaint stating that while he sympathizes with homeowners who find out their homes are not worth what they thought, but indicates he did complete the appraisal with due diligence. Respondent stated that the complainant did not have a complaint with incorrect information about their home, rather only the value. Respondent stated that he felt the complaint was filed because they were upset they could not get the loan and just wanted their money back. The reviewer's conclusions are fairly short and listed there. So I'll give you a few minutes to look at those, and then we'll do the recommendation.
I'm going to interrupt just a second and let the record reflect that Commissioner Hall is here, and he arrived about 9:10 from Brentwood, Tennessee.
Thank you, sir.
Thank you. All right. Everyone had opportunity to review the conclusions? Ms. Gaber?
Potential violations found by the reviewer seem to revolve around a lack of supporting data and explanation. As such, council recommends that this matter be closed with a letter of instruction.
You've heard the reasoning and recommendation from council. Do we have a motion?
So moved.
Accept the recommendations of the council.
We have a motion from Commissioner Hall, seconded by Commissioner Walton, to accept council's recommendation. Any discussion?
Was the previous action, did that also have to do with the lack of information provided?
Are you talking about the previous one listed in the disciplinary
Yes.
history? That I do not know. Do you know that? I don't specifically know what that one was about. Sorry.
Any further discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Recommendation approved. Ready for item 4? That's ID number 2014-012-701.
Complaint was filed by a consumer and alleged that respondent undervalued a residential investment property in an appraisal report completed in October of 2013. Complainant alleged that the results of the appraisal cost her several $100s. The subject property is a furnished model home in a new subdivision. Complainant alleged respondent refused to do a reevaluation for the lender. Respondent sent a response indicating the complaint appeared to mostly reflect concerns with the loan process. Respondent indicated he had not had any contact from the complainant or the lender to complete a reevaluation of the appraisal. The instructions in the engagement letter were to complete an appraisal for a refinance transaction for the above referenced property on the SFR 1004 form with rental, comparable, and operating income statement forms. These items were included in the delivered report. Documents included in the complaint suggest that complainant supplied comparable sales to the lender. Respondent stated he was not provided any comparable sales and not requested to complete a reevaluation. Respondent stated the complainant has not provided documents to support concerns with the appraisal. The majority of the concerns appear to be directed at the client's loan process. Respondent stated he is independent of this process. The reviewer's conclusions are listed there. They're kind of lengthy, so just take a few minutes to review those.
Everybody had an opportunity to read the conclusions? Comments? Ms. Camber?
The respondent has been disciplined in a previous consent order for failing to adequately summarize relevant information in his appraisal report and support the site value and cost approach. The above noted violations occurred after the corrective education was completed in June of 2011. Because the respondent has not improved in report writing specifically and the requirements to report the support for value indications within the appraisal, council recommends the authorization of a consent order in the amount of $1,500 and a 15-hour USPAP course. No continuing education can be obtained for the 15-hour USPAP course, such terms to be settled by consent order or formal hearing.
Heard the recommendation from the council. Any discussion? Or is there a motion?
So moved.
We have a motion from
To accept.
Commissioner McCara.
What was that motion? Was it?
To accept the recommendation of council.
We have a motion to accept the recommendation of council from Commissioner McCara,
I'll second that.
seconded by Commissioner Collinsworth. Any discussion? Not all in favor signify by saying aye.
Aye.
Any opposed? Recommendation approved. Okay, we're at item 5, and it is about 10:24. I think the administrative judge is supposed to be back here at 10:30. Is that correct, Mr. O'Brien?
Probably just we
Okay.
have enough time to finish
So-
the legal report. If she's
Well-
not here yet.
Yeah, we do, but do we want to take a break, or do we want to start at 10:30 when she gets here, or do you want to continue on and then we'll wait 5 minutes? Because once we get into formal hearing, we probably would like to move on and not break. So what would this body like to do?
I'm fine with moving on.
Okay?
I say we push through these last 3
Okay.
cases here and then take
All
a
right,
break.
fair enough, let's go. We're on item 5, 20140124331.
Complaint was filed by the administrative staff for the Tennessee Real Estate Appraiser Commission as a result of a letter that was sent by Respondent AMC indicating that the company that owned the AMC pled guilty to conspiracy to violate Section 72062 of the Internal Revenue Code by assisting in the preparation of false income tax returns and other documents. Each of the plea agreements and consent orders resolved the respective investigation into the conduct. Counsel for Respondent sent a response to the complaint stating the company that owned the AMC entered into a detailed plea agreement with the United States Department of Justice on May 19, 2014. The plea detailed the terms of settlement and related only to violations of Title 26, United States Code Section 72062, the aiding, assisting, procuring, counseling, and advising of the preparation and presentation of false income tax returns to the IRS. Respondent stated none of the conduct subject to the plea is attributable to or involved any affiliate engaged in activities in Tennessee. The copy of the plea was sent to the Tennessee Real Estate Appraiser Commission in the spirit of full disclosure and not as any indication of any violation or guilt. The plea did not impact the company's charter or licensing with any of its regulators. There is no identity of management either in officers or directors between the owning company and Respondent AMC. Respondent expressed appreciation for the opportunity to respond, however, stated that they have not violated any provision in spirit or the letter of the law. It appears this matter has been resolved with the proper authorities through the details of the above-mentioned plea agreement. This matter revolves around federal issues with no direct connection to the state of Tennessee. Thus, counsel recommends this matter be closed with no further action.
You heard the council's recommendation. Do we have a motion?
Motion to accept.
We have a motion to accept council's recommendation from Commissioner Johnson. Is there a second?
Second.
We have a second from Commissioner Hall. Is there any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Recommendation approved. Item 6, case 2013-019-811 and 2013-020051. This is a re-presentation. Ms. Gamber.
This complaint is being represented from the January 2014 Commission meeting, during which the Commission voted to authorize the voluntary surrender of Respondent's AMC registration for failure to maintain a valid surety bond with the state, as required by the laws and rules of the Real Estate Appraiser Commission. Respondent did not respond to the state's attempts to contact Respondent regarding the bond. The facts of the matter as they were presented at the January 2014 Commission meeting are listed there. Rather than read them, if you guys just want to kind of briefly look back over those and review them, since you've really already seen them once, that would probably be better.
Yeah, you're recognized,
Have a-
Commissioner Hall.
I have a quick question here.
Okay.
In reading over this, I noticed that there
can't hear.
authorization to be here.
I'm sorry, I can't hear what you're saying.
If I'm reading this correctly, it appears that their authorization to be in Tennessee expires on August the 20th, correct? Of
Correct.
this year,
Yes.
2014? If they should come in between now and that point in time, what happens?
Their renewal wouldn't be granted because they don't have a bond.
If they were to have a bond and come in and say, I want to be reinstated, what happens at that point?
have to answer the complaint that's currently open.
I just do, my concern is, what I'm trying to clear up in my own mind, is whether or not they can come here on the 19th of August and say, oh, I'm sorry, here's my money, I want to be put back in business again after all of this time. And I just don't want that to happen.
It's exceptionally unlikely, but potentially they could in the next 9 days try to make everything whole.
They still have
And
to
they've
come
been
back.
authorized for a formal hearing, so that would still have to happen then.
They would still have to come back for a formal hearing before we could give them that bond. Is that correct?
Right, because it's already, I mean, the formal hearing has already been authorized, so basically it's in that stage now.
Okay. Okay, I just want to make sure they were not going to be able to slide in here at the last minute, you know.
Not without a formal.
Okay, thank you.
Everyone had an opportunity to read the background on this. Okay, Ms. Gamber, you're recognized.
So basically, since this item has already been authorized for a formal hearing, respondent's registration expires on August 20th, 2014, which is 9 days from today. Since respondent will no longer hold a valid registration after this date, council recommends this matter be closed and flagged on August 21st, 2014, in case respondent applies for registration in the future. If respondent does reapply in the future, the matter will be reopened and processed accordingly.
Heard council's recommendation.
Make a motion to accept.
Commissioner Collinsworth, you're recognized.
I'll second.
We have a motion from Commissioner Hall, seconded by Commissioner Collinsworth to accept council's recommendation on closure and flagging. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Motion approved. Item 7, 2014003781. It's a re-presentation.
Yes.
Ms. Gamber, you are recognized.
This matter is being represented from the April 2014 commission meeting, during which the commission voted to authorize a voluntary surrender of respondent's AMC registration for failure to maintain a valid surety bond. And this one is sort of similar in that their registration is going to expire on August 27th, 2014. And at that point, they will no longer hold a valid registration. So council recommends this matter be closed and flagged on August 27th, 2014, in case respondent applies for registration in the future. If respondent does reapply in the future, the matter will be reopened and processed accordingly. This one has also been set for a formal hearing, so it's basically kind of the same situation.
You've heard the representation and council's recommendation on this particular case. Anyone entertain a motion?
Make a motion to accept.
We have a motion from Commissioner Hall to accept council's recommendation on closure and flagging on August 27, 2014, seconded by Commissioner Johnson. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Motion approved. Item 8, case number 201-401-6541. Ms. Gamber, you're recognized.
Complaint was filed by the administrative staff for the Tennessee Real Estate Appraiser Commission after receiving notice of cancellation of respondent's surety bond. On July 30th, 2014, the administrative office received written correspondence from respondent stating it was giving official notice of his intent to surrender its AMC registration. Since respondent surrendered its registration, council recommends this matter be closed with no further action.
Heard council's recommendation. Is there a motion?
So moved.
Commissioner Hall is recognized
Second.
and made a motion to approve, seconded by Commissioner Collinsworth. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Okay, motion approved. Okay, that concludes the legal report. If we want to, we can continue on with the experience reviews. Judge, I do not see the judge yet. Okay. Next item, experience reviews. Not sure what page that is on your iPad, but
32. Page 32.
Okay. Thank you. At this time, I'll turn the the chair over to Vice Chairman Walton so I can give my committee report.
All right. Chair recognizes Commissioner Johnstone.
I had the opportunity, pleasure to interview Mr. Matthew Stevens Myers, who is a trainee, 3213, and he's requesting an upgrade from trainee to certified residential, and I would recommend approval of that upgrade.
All right, we have Commissioner Johnstone's recommendation. Do we have a motion?
So move.
As far as discussion goes, that is based upon passing the exam. Correct.
Yes.
He's done
Yes.
it. Then I'll second that then.
We have a motion by Commissioner Norman Hall, second by Eric Collinsworth. Any discussion? Seeing none, we'll have a vote. Vote in favor by saying aye.
Aye.
Any opposed? And the motion carries. We'll pass the chair back to Commissioner Johnstone.
Thank you, Commissioner Walton. At this time, I have seen the administrative judge is here, so we're going to stop on this particular experience interview. We'll pick up with Mr. Byron Neal Montgomery. I believe Mr. Hall interviewed earlier, and at the conclusion of this other business. At this time, did you have a?
Mr. Montgomery's waiting to hear his recommendation.
Oh, is he here?
Could we, yeah, could we
Okay.
just do his so that he doesn't
Okay,
have to wait?
I'm sorry, I apologize, I didn't realize he was still here. Okay, well, if the judge would mind, we'll get this one more item out of. Okay, Commissioner Hall, you're recognized, sir.
Yes, I had the opportunity this morning to speak with Mr. Brian Neal Montgomery. We went over the various reports that he had submitted. We talked about them, and I'm going to recommend that we approve Mr. Brian Neal Montgomery, subject to him submitting one more income producing appraisal report to me for review, which will be processed through Nicole, assuming that this report is 100%. I think 75%, okay? 75% be better? Okay. He'll be able to set for his exam, and this will be done as soon as he submits the report to me.
You've heard the Commissioner's recommendation. Any discussion? Is there a motion for approval?
I'll move we accept and approve Mr. Hall's.
We have a motion to approve Mr. Hall's recommendation for upgrading with the stipulations. Is there a second?
Second.
Seconded by Commissioner Walton. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? All right, it's approved. Thank you for staying around.
Thank you.
Thank you.
Let me ask the judge, we've got three others, and they shouldn't take but 2 minutes possibly. Can we conclude the experience review, and then we'll take a short break to get set up, if that's okay?
We're having copies made for the respondent as well.
Okay, fantastic. All right. At this time, I'd like to recognize Commissioner Point, who had the opportunity to interview Mr. Kerry Wayne Risley. Ms. Point, you're recognized.
I completed the interview, but in the midst, we switched over from trainee, instead of trainee to licensed trainee to certified general. We went up to Miss Nicole's office and checked his records, and he had the opportunity to move up, and his work was of such quality, and he's been a trainee for 10 years. He's had all the courses. He had over 4,000 hours of experience, and his reports were very good. So I would recommend that we approve him to go from trainee to certified general. That's unusual.
Well, you've heard the report of the experience interview from on Mr. Risley, with the recommendation from Commissioner Point that we approve the experience request subsequent to the passing of the exam. Does the chair hear a motion to adopt Commissioner
moved.
Point's recommendation?
So moved.
We have a motion from Commissioner Hall, seconded by
Second.
Commissioner Johnson to approve that. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Okay, recommendation approved. We'll now hear a report on the experience review from Commissioner Walton regarding the experience of Cody Daniel Powell, trainee 4425.
Interviewed Cody today and reviewed his reports and found them to be more than satisfactory. And it's my recommendation that he be approved to take the exam and upgrade to certified residential.
Okay, you heard the report of the experience interview for Mr. Powell with the recommendation from Commissioner Walton that we approve the experience request. Does the chair have a motion to adopt the recommendation?
I'll move we accept the recommendation.
We have a motion to accept the experience request recommendation. Any discussion? Is there a second?
Second.
Okay, we have a motion from Commissioner Collinsworth, seconded by Commissioner McCara. Is there any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Okay, the experience request has been approved. We'll now hear a report on the experience interview from Commissioner Collinsworth on a Mr. Timothy Michael Herman, trainee 4741, regarding the applicant's experience. Mr. Collinsworth, you are recognized.
Yes, I conducted an interview this morning with Mr. Herman, and after having the interview with him and discussing various aspects, it is my recommendation, and upon passing the exam, we do accept the upgrade request from trainee to certified residential.
Okay, you have heard the report of the experience interview for Mr. Herman with the recommendation that the Commissioner Collinsworth would approve the experience request. Do we have a motion to adopt the Commissioner Collinsworth recommendation?
So moved.
Second.
So we have a motion to adopt the recommendation from Commissioner Walton, seconded by Commissioner Hall, to approve the experience request. Any discussion? If not, all in favor signify by saying aye.
Aye.
Aye. Any opposed? Okay, the experience request is approved, and that concludes the experience interviews. One thing I just noticed that might help clarify some things, and in looking at the chart, it says upgrade requested. Technically, we're not doing the upgrade, we're just approving the experience, and they would have to follow through with the rest of the process on the upgrade. So I think as far as approving, making it subject to the passing the test, I don't think is technically appropriate. I think all we have to do is either give them a thumbs up or thumbs down on the experience. On the experience. Is that correct, Ms. Avers?
Just the experience
Just
is what needs to be approved.
Okay. All right. That concludes this portion of our meeting today. We're going to take a 5-minute break to allow the judge and court reporter to get prepared, and then we'll proceed with the formal hearing. Time now 10:42. We'll convene back at 10:47.
Not as well as it should. I'm sure you have a picture or two here. You know I'm going to have those.
Well, I kind of had a
Quality's nowhere near as good as her, but that's when last week. So I had to grab a photo of that. Right
Oh,
quick.
my Lord.
She started out at 5 early.
Coming on up.
That's right.
Coming on up. Oh.
How's everything going?
Go the second time. So this is the fourth time, so that's
Fourth time? There's 11 copies in there.
Oh, okay.
Oh, you mean for, well, that'll be in the technical record.
This meeting, August meeting of the Tennessee Real Estate Appraisal Commission will come back into order, and it's at 11:03. And we are getting ready to begin a formal hearing. But before we start that, I do want to recognize a visitor we have. We have a past member of this commission and chairman, Mr. Don Turner. Thank you for being here today and observing. And he has the esteemed CG number 11. And his wife was the first chairman of this commission, Miss Lula Turner, and she has the esteemed CG number 1. So she was the very first one. So whatever your numbers are, you'll see how you stack up there. So anyway, thank you for being here, and hopefully the baby is growing and is healthy. Well, appreciate you being here today. At this time, I'm going to turn it over to Administrative Law Judge Judge Ball, and she will give us our marching orders. Ms. Ball, you're.
Good morning, everyone. We're on the record. This hearing is now convened before the Tennessee Real Estate Appraisal Commission to consider the matter of Roger Cameron. That docket number is 12.36-125633A. I'm Joyce Ball. I am the Administrative Law Judge assigned by the Secretary of State to preside over this matter. In that capacity, I will make rulings regarding the order of proceedings, admissibility of evidence, and questions of law under authority granted by the Tennessee Administrative Procedures Act. I will not participate in the findings of fact or the ultimate decision. The decision will be made by the board members. In this proceeding, the state will be represented by Attorney Adrian Chick. The respondent, Mr. Cameron, Roger Cameron, is present. Mr. Cameron, do you want to proceed without an attorney?
Yes, I do.
Okay. Let the record reflect that Mr. Cameron has waived his right to an attorney. At this time, I will ask the board members to introduce themselves for the record, please.
Nancy Point, Rogersville, Tennessee.
Norman Hall, Brentwood, Tennessee.
Eric Collinsworth, Arrington, Tennessee.
Mark Johnstone, Jackson.
Tim Walton, Collierville.
Rosie Johnson, Paris.
Fred McCara, Johnson City.
Thank you all. Okay, members of the board are reminded that during the time this hearing is conducted, no discussion concerning this case should take place with anyone outside the room unless all parties are present. During the hearing, the board sits as a jury and must only consider the evidence introduced at the hearing. It is improper for you to discuss this matter amongst yourselves or to draw any conclusions until all the proof is in. The Sunshine Law requires all board discussions and deliberations to occur in public and in the presence of all parties. Failure to comply could result in the board's actions being reversed or remanded if your decision is appealed. Do any members of the board have any knowledge of the facts of this case from any outside source? Okay, thank you. Let's see. Are there any preliminary matters before we get started?
No, Your Honor, we are not requesting the rule, so, of course, Ms. Avers, she would be the agency representative that'll be sitting here.
Okay. Any other matters before we get started? Okay, at this time, I will ask Mr. Chick if he could, you You may make an opening statement, Mr. Chicken. Also, I believe you've already passed out the notice of charge. Is that correct?
Yes, Your Honor.
Okay. And you may make an
Okay.
opening statement if you like.
Would Your Honor prefer that counsel that we stand or?
You may sit.
Okay.
That's fine, whichever's
Okay,
more
thanks.
comfortable.
It's certainly easier
Yeah,
to
okay.
access the documents.
Sure.
Good morning, Commission. My name is Adrian Chick, Assistant General Counsel, and I just want to say a few brief words to tell you what the state expects to put before you today. Mr. Cameron is a real estate appraiser, and the state will show that when submitting his certification of taking continuing education that's required by your statutes and rules, that he waited until the last minute basically to take the course, and the provider did not have a pre-issued certificate for him, and to avoid having to pay the $100 late fee, he photocopied, took a picture of another person's certificate of completion, whited out the names, put his own, and submitted that in. So as you're aware, the statutes and rules not only require certification that's satisfactory to the commission from these providers, they also require the providers to maintain records and to be able to state who was in class that date. So that is the gist of the state's case. Thank you.
Mr. Cameron, would you like to make an opening statement?
Yes, please.
Light up when you can be heard.
Just wanna slide over here.
Oh, okay. A little better. Okay, when I first got notice of this, I wasn't really serious. I can assure you I'm serious about it today. My integrity is utmost importance to me, and I've made a career in my real estate appraisal life as being, diligent and having highest integrity. A good percentage of my work is as a real estate expert in court, so obviously any kind of questions about my honesty and integrity would be quite a problem. When I did the actions that I did not believe I was misleading anyone, and I think that I will prove here this afternoon that that was not my intent. I think certainly intent has a lot to do with the results here. They keep making references to a certificate, and certification is not that. It is a student transcript. It is not the uniform request for continuing education credit, which is required by law. Perhaps the way I handled things weren't of the best in hindsight, but again, I had no intent to defraud or to mislead anyone, and I don't think that the state will prove that I did that at the end of that. It is true that November the 13th was the last day for my 30th day prior to license renewal, and of course I wanted to save $100 like anyone else did. I registered for the course in a timely manner. When I took the course, they did not have a copy of the student transcript for me. I never got a student workbook. I had to specifically request the uniform request for continuing education document from them, and I received it approximately a week or so later. There's no doubt that I whited this out. I did so believing that I had the instructor's permission to do so, and I've never denied any of the actions that I took. So I've tried to be upfront and very clear about all of that. I did in fact call the instructor when this became a question. He told me at the time he did not have any memory of me in the class.
Mr. Chair, excuse me, I think you're getting into your proof now, but
All right, well, I don't think they will prove their case. I don't think there will be a reasonable doubt in your mind when this is all said and done. Thank you. Sorry.
Thank you, Mr. Chair, okay. Mr. Chick, I'll start with you. You may call your first witness.
Your Honor, the first witness I'll call will be Ms. Nicole Avers.
Morning. Could you raise your right hand, please? Do you swear or affirm that the testimony you're about to give be the truth and nothing but the truth?
I do.
Thank you.
Good morning, Ms. Avers. Will you please state and spell your name and tell what your title is?
Nicole Marie Avers, Nikole Marieavers. And I'm the Executive Director of the Tennessee Real Estate Appraiser Commission.
Ms. Avers, in your capacity as the Executive Director of this commission, are you in charge of licenses and renewals and continuing education, et cetera?
Yes, I oversee the licensing function. I process complaints, and I'm the custodian of record.
Are you familiar with the respondent in this case, Mr. Roger Cameron?
As a licensee, yes.
Can you tell the commission when he was first licensed and what his license number is?
Mr. Cameron's license number is 426, and he was first licensed December 13th, 1991.
And at the point that the complaint was opened, when was his license set to expire?
It was set to expire December 13th, 2013.
In order to renew his license, was he required to submit any proof of continuing education?
He was required to submit 28 hours of continuing education 30 days before his credential expired, so that would have been by November 13th, 2013.
According to the law that was in effect at that time, if he had failed to submit that proof by November 13th, 2013, what would have been the result?
Late fee of $100.
Okay. Are you familiar with the Columbia Institute?
Yes, that's one of the schools that are approved course providers.
Ms. Avers, there's a document in front of you. It's actually, should be the stack on the left. It's the state's collective exhibit. I believe it might be on your right. It's got highlighted block on it. Could you look through that and see if you, in general, can tell what this document contains?
There's a series of emails between Mr. Cameron and the generic reg board's email address, and then his continuing education, which was attached to the email address that he sent. There's an email from Jean at Columbia Institute to me.
That's fine. I just wanted you to tell us whether or not those are general documents regarding the renewal. Okay. Ms. Avers, are the applicants and the licensees for this commission, are they permitted to submit applications for renewal online? Yes. Are they also authorized to submit copies of proof of education online? Okay. If you would, this document at the lower right-hand corner, I've placed Bates numbers on these, sequential numbers. If you would, look at page 26, and up at the top, tell me who that email is from. Received it. And if you would read that statement.
This email is from Jean at Columbia Institute to me, and she CC'd Brian Reynolds, who is the course instructor. It reads, Miss Avers, I wanted to clarify Columbia Institute's policy regarding course certificates. We send the instructor certificates for students that have registered with us at least a week prior to the class. Each certificate contains the student's name and address. We do not include their license number. Students may write in their license number. If a student registers later or walks into class, the instructor will not have a certificate for that student. We do not send blanks. If a student needs a certificate immediately, the instructor will email or call us to let us know about the student's attendance, as Mr. Reynolds did. We will then email the certificate to the student. I don't know how other providers handle this situation, but Columbia Institute has never provided blank certificates or suggested to a student to white out another student's certificate. Jean Crane, Columbia Institute.
Thank you. Would you also look at the first page? And the first page, actually pages 1 through 4, and tell me what that represents.
Page 1 is the email from Mr. Cameron indicating he is submitting his continuing education. It says, hello, I'm renewing my appraisal license, CG 426. I wish to send these certificates of completion for classes I have taken for continuing education. I did not find a way to send them on the website when I paid my renewal. Please advise if you need hard copies. Page 2 is the certificate in question where the address and the license number had white out. Page 3 is a course from McKissick. Page 4 is a course from Trees PAT course. Did you want to go on?
Just through page 4, please. Okay. We'll take a look at page 8. Blocked part and explain what that is.
At the top in the shaded area. It's an email from Jean at Columbia Institute, and it says here is the original certificate. It's dated November 15th, 2013.
Okay, when you received the questionable certificate, or let me ask you this, when you received that certificate that appeared to have whiteout, what was your thought at that point?
Well, I had never seen anyone submit a course with whiteout on Columbia Institute's certificate before, so I started an inquiry into that. I contacted Mr. Cameron. I also contacted Columbia Institute and the course instructor to ask if something had occurred there. I followed up with each of them.
Okay, let's look on page 11. Is that the result of one of these inquiries that you're talking about? Okay, would you tell us what that is and read that response?
This is Mr. Cameron's response. Hello, Miss Avers. Attached is a copy of my transcript. For some reason, it was not ready the day of the class, and the instructor had to give me a copy to put my name and information in. Here is the official version. I would appreciate it if you did not delay my license renewal or require me to pay the additional $100, since not having a certificate ready was not my fault. Please advise and have a great weekend. Roger Cameron.
Okay, let's go to page 13 and start with the second block, please.
The second block begins, it's an email from me to Mr. Cameron. It reads, Mr. Cameron, specifically, tell me how you came to be in possession of a course certificate with white in the name area and license information. Who provided this to you, or did you do this yourself and submit it to my office as an altered course certificate?
In the first block.
Miss Avers, I put my name and address in the spaces and used whiteout because of coloring in the areas which would not have allowed the name and address to be legible.
And page 15, the block at the top of that page.
It's an email on November 15th from Mr. Cameron, and it said, Miss Avers, here's a copy of the course certificate emailed to me absent my license information, which I have written in. There was no intent to fraudulently alter anything. Many classes hand out certificates that are pre-signed with the recipient's name and address and license information blank to be filled in by the student. I did, in fact, attend the class for the full time period, but they were short on certificates at the end of class.
Thank you. On page 18, would you explain what that email is about and read that to us?
This email is an email from Brian Reynolds, who is the course instructor for Columbia Institute. It begins at the top. It says, Brian Reynolds to Nicole Avers. Below was the request I sent the other day. I'm still in shock about this, Brian. And below that, you can see his email to Columbia Institute. It was dated at November 13th, which is the date in question of the class, to Gail and Dell at Columbia Institute and Jean, all CC'd on that. And it says, the following student needs his certificate ASAP. Roger Cameron with his email address, appraisalexpress@aol.com. Wednesday class. Thanks, Brian.
Thank you. And what was the time that email was sent from Mr. Reynolds to Columbia Institute?
8:52 p.m.
So that would have been the evening after the class?
Yes.
Okay. Page 19, let's look at the second block.
And it's an email that I wrote to Mr. Cameron, and it states, Mr. Cameron, where did you get the course certificate to alter? Why would the instructor have given you a course certificate document to alter?
And now let's do the first block.
Miss Avers, there were simply not enough pre-signed course certificates to distribute to the entire class, but the instructor did not discover this till all the others had been handed out. I would like to state that all of the course certificates from this class will be altered by the students with their personal information because none were completely filled out prior to distributing them. So if I'm guilty of altering the certificate, then so is everyone else in this class, and probably every other continuing education class ever presented. The companies that put on these courses often don't have all the students' personal information and send blanks to be completed by the student after class. This is standard procedure. I have been a course coordinator for IRWA on several occasions, and they routinely send pre-signed course completion certificates and/or requests for continuing education, and most do not have any student personal information pre-completed, not even the student's name. Filling in the personal information is usually done after the class is over because there is no way to predict how many people are not going to show up for class, and often there are people who register the day of the class. In fact, at least 50% or more of the course certificates and the request for continuing education credits I have seen are altered by the student after they are distributed after class. They almost always come pre-signed by the course provider with the personal information section left blank to be filled in by the students. This class was no different. They simply didn't have enough to go around, but this was not discovered by the instructor until all of the others had been distributed. There was no copying machine available, so I photographed one and printed it when I got home and filled in my personal information. This would have been no different than if I had made a copy of it prior to leaving. I would also like to point out that the course completion certificate that I emailed to you earlier today was altered by me after receipt from the course provider because I had to fill in my license number. Again, there was no attempt to defraud or mislead the commission, and I apologize if it appeared I was attempting to do so. If I had seriously attempted to do so, I would have done a better job trying to hide it. There simply was no false information provided, and I did, in fact, pre-register for the class, and I attended the class for its entire time, as you have already confirmed with the education provider. Again, I apologize if it appeared I was attempting to defraud or mislead the commission, but that was not the case. Thank you, Roger Cameron.
Thank you. And let's go to page 22, the top block.
This is dated November 18th from Mr. Cameron. It's an email from Mr. Cameron to me. It says, Miss Avers, please forgive me for taking so long to get back to you regarding this email. I did not know it was apparently in my inbox since last Friday. Today I had outpatient surgery and have only now seen this email and have become clear-headed enough to make a partial response. I am in no position to make a full response at this time and ask that you give me until Tuesday afternoon, November 19th, to make a more detailed explanation. I don't want to carelessly choose my wording, as having done so already has served to confuse the situation and make me appear dishonest. I am on the Tennessee Department of Transportation fee appraiser panel and have worked for other state agencies and for plaintiffs and defendants in litigation, and any appearance of dishonesty is death for my career. Please don't misunderstand that statement as begging for you to look the other way if you in fact believe me to be dishonest. I am only asking for enough time to clearly state my position and describe my actions more accurately, as my haste to answer your previous questions has made me appear badly. I admit that my actions were done in haste and I did not handle it well, as is obvious. But I did not intend to do anything wrong. I was in the class, and that is undisputed. Regardless, would you allow me that amount of time to answer more fully, or would you prefer me to submit my appraiser license back to the commission? Sincerely, Roger Cameron.
Thank you. Did you, in fact, allow him additional time?
Yes.
Go to page 30. Explain what this email is about.
This is the November 19th email Mr. Cameron submitted to me regarding the complaint notice.
Would you read that, please?
It reads, Miss Avers, thank you for allowing me additional time to respond and to try to clarify things. In my earlier answers, I did not understand the gravity of the situation from your point of view and did not choose my words wisely in my attempt to summarize my actions and motivations. I will do my best to be explicit from now on. The instructor, Mr. Reynolds, did not tell me do what I did. I'm sorry, I didn't read that very well. Everything I did on my own accord. At my request, the instructor, Mr. Reynolds, stated that he was going to call or email his company and request they send me the required documents as soon as possible, and he could not guarantee when it would arrive in my email box, but that he expected it to be later that day. I asked if he had any blank student transcripts or uniform requests for education credit, and he said he did not. I did this at the end of class when it became obvious he had nothing to give me to prove that I was in class. There were several people standing around talking to him, and I begged to interrupt and obviously did not make myself clear to him what I needed. As I have stated before, absent a copying machine, I took a photo of another student's transcript, whom I did not know, and used whiteout to fill in my name and address.
Your Honor, the state has previously obtained an affidavit from this Mr. Brian Reynolds. I don't believe I've passed that out. But that was sent to Mr. Cameron. There was no request to cross-examine made, so if there's no objection, I'd like to enter.
He's not available for me to cross-examine. I realize Can you not hear me? Excuse me.
So you sent this to Mr. Cameron?
Yes, Your Honor. I mailed this to Mr. Cameron. Federal Express, June 24th, 2014, and have never received a written response from him.
Cameron, did you receive this?
Yes, I did.
Okay. Did you not respond?
No, I didn't. I didn't realize until now that I had a 7-day I guess I do have questions about the production of this. I don't know, should I ask this witness of that, or how would I address that?
Well, I believe that you had an opportunity to respond, and you did not. He said he sent it June 24th. Okay, so you've had your opportunity to respond and to critique it, but
I would have an opportunity during cross-exam to raise questions about this since Mr. Reynolds is not available.
I believe your opportunity is up, Mr. Cameron.
What I was interested in is who produced this document. And I'd asked previously for emails from the from council here and from the Appraisal Commission back and forth to the Columbia Institute and to Mr. Brian Reynolds supporting the receipt and the request for this affidavit. I have not received any of those.
Your Honor, Mr. Cameron asked for emails between the commission and staff, and we supplied all of those very early on. This affidavit was obtained from Mr. Reynolds, and I'm not sure what other explanation I can give Mr. Cameron. I've got the original here that clearly has his original signature and it's notarized on it. He was offered the opportunity. The notice very clearly states that you have 7 days to request cross-examination, and that otherwise the affidavit will be introduced as evidence. He will not be called to testify, and you will not be entitled to question the affiant.
I'm sorry. Your Honor, I understand the affidavit will be introduced since I did not object within 7 days. My question is, I had asked for emails surrounding this document as to Mr. Reynolds. I want to know who requested the document. I'd like to know who prepared the document, whose words these are. I have seen many affidavits in my lifetime, and I've never seen any that had the style of the case at the top, and also most of them will say, based on my personal knowledge and beliefs, the following is true. That's not contained in here, and I just am asking who prepared this document, whose words are these, and was it sent to Mr. Reynolds for him simply to sign, or did Mr. Reynolds in fact write this himself? That's why I asked for the emails surrounding this, so I could ascertain as to who it was that prepared this. And if this was prepared by counsel here, then I would object that these are not necessarily Mr. Reynolds' words, but words that were provided to him.
Well, Your Honor, I think I see what Mr. Cameron is asking. What he's asking for is essentially attorney work product. He's asking for the communications between counsel and a witness, and I believe according to the rules of civil procedure, if he has exhausted his normal means of getting that information, which would be questioning Mr. Reynolds, sometimes if he makes a certain showing, he can request counsel to release that, but otherwise what he's asking for is attorney work product. I don't mind saying on the record that I provided an initial statement to Mr. Reynolds. He had some changes that he wanted to make. I incorporated those. We hand delivered this statement to him while he was in Nashville doing a seminar, and he signed it, and that's the logistics of it. But
I'm going to let it in. Okay.
Please, Your Honor, I'd like to pass out I think there's enough for everybody. Your Honor, since Ms. Avers is still on the stand and doing an excellent job, could I ask her to read this one-page affidavit, please?
All right. From the beginning at the first page, or at the?
From the page, it starts off, I, Brian S. Reynolds.
All right. I, Brian S. Reynolds, do hereby state under oath as follows. I am a licensed certified general real property appraiser in Tennessee. and an AQB certified USPAP instructor. On November 13th, 2013, I taught an 8-hour course provided by the Columbia Institute entitled Residential Sales Comparison, the Adjustment Process, number 151, in Knoxville, Tennessee. The Columbia Institute is approved by the Tennessee Real Estate Appraiser Commission, initials, to provide this course to satisfy continuing education requirements. Roger Cameron was in attendance for the duration of the November 13th, 2013 course. Columbia Institute provided student transcripts for me to distribute at the end of course. However, I was not provided a student transcript in advance for Roger Cameron. In my experience, this is not uncommon, especially when students have not registered far enough in advance of the course. When this occurs, I notify the course provider that the student needs his or her transcript. I have never altered another student's transcript, nor have I ever directed or suggested that a student alter the transcript of another student. At the end of the course, Mr. Cameron inquired about his transcript, informed me that he needed it immediately. By email later that night, I informed the staff at the Columbia Institute that Mr. Cameron needs his transcript ASAP. Further, the safe not, Brian S. Reynolds.
Savers, have you ever received a course completion certificate or transcript from Mr. Cameron from where he had taken a course at the Columbia Institute, other than this one?
I don't recall. I have to look through my records. I may have. I receive a lot of course certificates.
Okay, what about from the Appraiser Foundation, such as, I believe there's a document.
Well, this one's from the Appraisal Institute.
Based on that document, what course was that he had taken?
Business Practices and Ethics at the Knoxville Association of Realtors.
Send in a uniform request for credit with that one?
No.
Okay. How does the submission of evidence from the courses work? Tell us what is required from the commission standpoint from the licensees as far as proof that they've taken a class.
They have to submit a course completion certificate. The course providers are required to provide the students with a course completion certificate. We have course completion certificates they can use. There's one available on the website if the school doesn't have one, or they're welcome to use their own as long as it has the information that we deem relevant. The name of the school, the name of the course, the amount of hours it's approved for, student.
Or I'm going to object. I don't have a copy of that document. I would like to see that, please.
I'm not, don't intend to ask it to be introduced.
Any chance I could get a copy of this for cross-exam, please?
Yes, in fact, I've got a copy right here. No, that's,
Please may continue.
I mean, I don't care to introduce that as an exhibit. I was just asking her testimony. Savers, for the Columbia Institute and the course that is the subject of this hearing, does the commission require the form that's on the website, or is what they issue sufficient?
Columbia Institute is a very large national school. They offer courses in every state. They have their own template, and it works just great for submission. As far as I know, every state accepts their course completion certificate.
So is it your testimony that there's no uniform form required for those courses at the Columbia Institute?
We've never required an additional form from the Columbia Institute.
Okay, those are all the questions that I have, Your Honor, of Ms. Avers. And the affidavit of Ms. Reynolds, could I please get that introduced as an exhibit? Your Honor, would you like the original for your file?
Yes, please, I would.
I want to make sure the judge has the original, and the reporter will need a copy. Oh, okay. All right. And Your Honor, that's the state's case.
Okay, you can take that one back. Thank you, Ms. Avers. Mr. Cameron, do you have questions for Ms. Avers?
Yes, I do, and I move for dismissal. They've not stated a claim upon which relief can be granted.
I'm sorry.
I'm moving for dismissal. They have failed to state a claim upon which relief can be granted. Okay, then I'd like to examine the witness, please. Okay, Ms. Avers, let's just start here with the affidavit, since you were kind enough to read that in here. Down at the bottom of the page, would you please read again that next to the last sentence? It says, "I have never altered," where it starts there, that one sentence, please.
I'm sorry, could you tell me which document you're asking me to read from?
the affidavit of Brian Reynolds.
Your Honor, I'm going to object here. I did have Ms. Avers read that, but that's not her. She has no personal knowledge. She just read an affidavit that was introduced because it wasn't objected to. So she
Sustain. I sustain that. I mean, it's not her affidavit. She just read.
Okay, then I'd like to ask her a question about it. If she read it into the record, I'd like to ask her at least one question about this affidavit.
That she, that she didn't write, but she didn't write the affidavit.
Oh, but she was kind enough to read it for us. I have one question regarding the content.
I'm not going to allow you to ask any question regarding the content because she did not write it. Ms. Avers did not write the affidavit, okay? Do you have any other questions?
Yeah, would I be able to present that during my direct testimony?
Affidavit?
My comment about the affidavit, I should be able to present that during my direct testimony, should I not?
Well, when you present your proof, we'll just let me know what you're trying to get in.
Okay. All right, thank you.
Board members, do you have any questions for Ms. Avers?
I have more questions for Ms. Avers, Your Honor.
Oh, okay.
Yeah. I'm sorry, I'm not an attorney, so you have to bear with me. I'm just trying to do the best I can here. Ms. Avers, did I understand you to say just a minute ago that you have never required additional form from the Columbia Institute other than their student transcript as proof of continuing education?
I have never required an additional form from Columbia Institute, or really, I should say, from the licensee. If they have that form, that's the form we accept as proof of continuing education.
This is sufficient under state law, in your opinion? Yes. You're aware that state law requires that any request for continuing education that requires that it have a statement of the course content and that it be prescribed on the prescribed in Chapter 1255-4 under continuing education, and I'd be happy to look up the TCA if the court would give me time to do so, but are you aware that this does not meet the requirements of Tennessee Code?
I would indicate to you that that is not.
Okay. I have a copy here, and you have a copy of this is the procedure for the Tennessee Real Estate Commission under 1255-01-11, license and certificate renewal, item paragraph in parenthesis 3. Would you
I'm sorry,
kindly
repeat
find
that?
That would be in the documents that I gave you that were paper clipped. It has a
I didn't get any
page number
documents
16.
from you.
Yes, you did. They're laying right there. Sorry.
Okay.
Hey, that's not been introduced yet. The second, Your Honor, I believe he would be limited to what's already been introduced.
Exactly.
Okay, then my question is, in your opinion, does this student transcript meet the requirement of state law for continuing education credit to be granted?
Yes, it does.
All right. Typically, you're telling me then, as I understood it, that all of the courses that Columbia Institute has provided here and all of the students that have taken courses under Columbia Institute have simply given you a student transcript and have been granted continuing education credit based solely on the student transcript. Am I correct in understanding that's what you said?
That's what that form is called, yes. They put the title up at the top that says student transcript, but that is their course completion certificate. They give you that certificate at the end of their course, not until it is a course completion certificate and it meets the requirements.
Okay, I'm sorry.
It's signed by the course administrator, and it's provided to students when they complete the course.
Okay, does it state on here anywhere a description of the content of the course?
The name of the course is indicated, and since the commission reviews and approves all courses, the content is contained within our files for all of that, the content of each course. So if the course is business practices and ethics, say, then we have the content of every course approved on our website is saved in the commission's files.
Okay, Your Honor, I have some documents here that were introduced on direct. They were part of the the package that Mr. Chick gave as his collective Exhibit 1?
You have some questions about what's in this document?
Yes. This packet right here that he introduced as collective Exhibit 1, I'd like to ask a question or two out of that then, since it has been introduced as evidence. Okay, Ms. Avers, what is your position here
I'm
Yeah.
the executive director,
of the Real Estate Appraisal Commission?
correct?
Correct? And as such, then you would be expected to understand and know the requirements for your office. Is that correct? Okay. Are you aware that your very own office requires that any continuing education request be provided on the form that's prescribed by state law and available on your website?
Your Honor, I'm going to object that he's not laying a foundation. He's not. He needs to explain to this witness what rule or statute he's talking about.
Your Honor, I attempted to a minute ago. It's 1255-01-11, license and certificate renewal. These are the rules promulgated by the Real Estate Appraisal Commission, and it certainly specifies a particular form that any request for continuing education must be completed on, and that form has certain requirements as evidence that it was met the requirements of the law. And if you go to the website, it states very clearly here, this form was developed for reporting continuing education to the Tennessee Real Estate Appraiser Commission. And this form has particular items that are required under state law that are not contained on the student transcript. And the whole basis of their case against me is that I altered or forged or misled them by giving them an official document, which this is not. This is the official document required by state law. This does not meet the requirements because it does not have the course content and the other requirements that state law requires. And that's the whole basis of their case.
What is your question to Ms. Avers?
Thank you. So again, Ms. Avers, does this student transcript describe the activity and content of the course?
Yes.
Where? Would you read that to me, please?
Residential sales comparison, the adjustment process.
Okay, what is the words, the two words right before that? What does that say that is?
That's the course title.
Course title, okay. Does that describe the activity and content of the course? Because on this official form, it has two things. Title of the course, and below that, description of activity and content. Your student transcript does not contain both of those items.
The title of the course references the course that is approved. All of the other courses that you submitted also have only that information on it. None of the other courses on the form that you're talking about, which is only a blank template we provide for schools that do not have their own template, have no more information. The next course in your education certificate submission in that same series, it just says information on file for this course approved by the Tennessee Appraisal Commission. That's the summary on the next course that you're arguing about. All of the courses are referenced by their titles, and the course content is kept in the commission files.
Okay, what does this number 151 at the end here of that title signify?
The school has their own numbering system, and they wanted that in the title of their course.
Okay, so does this student transcript contain the commission-approved, commission-issued approval number?
It doesn't.
Okay. So if I'm looking at your very own Real Estate Appraiser Commission rules, and it specifies that each application for renewal of a license or certificate, and I'm going to paraphrase here,
Your
but I'm going to
Honor,
read the whole.
I'm going to object, just for clarification, I'd like for him to read the entire rule
That would
that
be-
he's talking about.
Be happy to, Your Honor. Each application for renewal of a license or certificate shall be accompanied by sufficient evidence of having completed the continuing education requirements for renewal specified in the Act, and they're talking about the Tennessee Code there, and the rules, and presented in the form prescribed in Chapter 1255-4, Continuing Education, and they're referring to this uniform request.
Objection, Your Honor. He can't testify as to what he can't interpret. He can read what it says, but he cannot offer his opinion as to what it means.
I don't think there's any doubt that that's what it means.
Staying, Mr. Chick. Any other questions? Mr.
Yes, I
Brown?
do.
You're asking about the course number?
No, I was just asking as to the content of the student transcript, and did it meet the requirements of state law?
I believe she's
And,
answered
well,
that.
she asked me a question back, Your Honor, so I was just trying to clarify that for her. I apologize. I don't mean to be argumentative. Just want to make it clear. Are you licensed, Ms. Avers? Do you have any professional licenses?
I'm certified appraiser.
Okay, so you've taken appraisal continuing education courses?
Yes, sir.
Have you in fact submitted your student transcript as proof?
Yes, sir.
Okay. Okay, I want to go to some of the emails that were back and forth between yourself and myself. And I think that they are part of the collective exhibit, or if not, they were referred to in his list of exhibits. I think he has a catch-all that says on all other emails and things that are relevant. So I'd like to pull it out of that stack if I may.
Are you going to ask her questions about emails from her?
Between her and myself, and from her, yes.
Okay.
Thank you.
Your Honor, if I may, I just want to make sure that the respondent understands that this is just his cross-examination, that
This is,
he'll still be able to.
yeah.
Yes, I understand that, but while I have a chance to ask her questions, I would like to afford myself the opportunity. And these are things that she wrote, so I think it would be relevant that she could answer them.
But you have an opportunity to put your proof on now, okay? This is just cross-exam, so I'll
Yes,
allow a few more
I understand
questions.
that.
All right?
Okay, thank you. Okay, the first thing is in the paperclip stack that I gave you as my collective exhibit 2. A few pages back, there is an email from you to me, and at the bottom of the page it has the number 3. Can you find it? It's in the stack there with a paper clipped in front of you.
Is it?
It will be when we discuss it here.
Are you talking about this one that's already been introduced from here?
Oh, ma'am.
No, nothing that has not been introduced.
Your Honor, he stated in his list of documents that he was going to present that it would include all the other email items, and this is one of those email items between Ms. Avery and myself. I would like to afford myself the opportunity to cross-examine her regarding some of her documents that she sent me. Your Honor, let me find his order, okay? Perhaps it would be quicker if Mr. Chick provided the order that he supplied to me as to his list of documents and witnesses. It's a part of the official record of the court.
Is the email in here?
I don't know, I'll have to look through that. But in his
Avers
list
has
of...
gone through some of the emails. Are you?
Your Honor, I think he's trying to introduce the first of his second collective exhibit.
Your Honor, the reason I'm trying to introduce that through her is because Mr. Chick identified all of these documents as documents that he was going to introduce. The fact that he did not copy them and bring them doesn't mean that they're not already introduced. If you will look at his order, he states that he is going to call her as a witness, and he's going to introduce all these emails. And the last thing on his list is all these other documents that he did not make copies of. All I'm attempting to do is provide them.
They question her about anything that she has testified to today, okay? If she has not testified to it, or if it has not been introduced, then you may not question her about that.
You go carry it home. Eat chocolates all the way back home. My Lucky Charms.
Old by now, right?
Okay, board members, do you have any questions for Ms. Avers?
I do. Find my pad. Real quickly, just for clarification, I'm in my mind. If the defendant had completed the state's form instead of whiting out the one that he sent in, would he have been in this predicament?
If he'd gotten the instructor to sign the form and submitted it, he would have been fine. But Columbia Institute doesn't really submit that state form.
And if he hadn't brought that form with him to class, he couldn't complete it on his own after the class, correct?
No, they really tend to be very quick at turnaround. If they get a walk-in, they usually email it to them within 24 hours, barring some unforeseen circumstance. But and generally, if that's the situation, I get an email from the course instructor or the course provider saying it was a last minute registration, they did attend class, I'll just hold off and not charge them a late fee. A lot of this could have been avoided if he had just told the truth when I asked him about it.
Object to that, Your Honor. Object to that characterization.
That's all I've got.
Other questions from board members? Okay. All right, now, do you all need a break or anything before we start with Mr. Cameron's proof? Well, anybody need a break? Cameron, you have the floor.
Okay, Ms. Sabers, in your file,
Oh, excuse me, would you
Yes.
raise your right hand, please?
yes,
Do you swear or affirm that the testimony you're about to give be the truth and nothing but the truth?
I affirm.
Okay, now, you may testify and talk to the board and tell them what you hope to prove today, or you may call a witness. Do you have a witness that you want to call?
Yes, I have two witnesses, including Ms. Avery, then.
Okay, so are you okay with them calling Ms. Avers? Okay. So all right, so Ms. Avers has been sworn in, and you may, she's your witness.
Thank you. Ms. Avers, in your file, do you not have a properly filled out uniform request for continuing education credit granted to me by the Columbia Institute in addition to the student transcript?
Are we talking about for the same course?
Yes.
I don't see one, but you may have submitted one at one point.
Okay, then I would like to refer you some emails in which I did send that official uniform request for continuing education credit filled out by the Columbia Institute, countersigned by me as is required by state law, in addition to the student transcript which Columbia Institute provides. Okay, Ms. Avers, in the collective exhibit 2,
I need to see that, Your Honor.
it would be in the appraisal commission's files. I may or may not have a copy with me. I presume, this being a question of my, whether I had taken the course and all of that, that they would have it with them because it was certainly submitted to the Appraisal Institute, or Appraisal
Your Honor,
Commission.
I'm
I'm sorry.
going to object to any questions about a document until he's
You have it,
laid a
Mr. Cameron?
foundation.
I'm looking for it, Your Honor. I did not think that would be an issue. I presumed that they would have it. My apologies. Okay, you have it? Sorry, I couldn't find it. Excuse me, I'm just a little bit nervous here, so.
I still don't see that. What packet of information is that in?
Stapled?
Stapled.
All right. Just the back. Well, Your Honor, I don't find mine, but we just stipulate that she has it. She's shown it to me there. It was also submitted. There's a couple of emails that go along with that between Ms. Avers and myself. So since she has this here.
Question about that document?
Yes, I just wanted to ask if she had received it, and there are some emails that surround that. I wanted to ask her a couple of questions about those emails.
Of the emails, Ms. Avers?
I don't know, he doesn't technically send anything in as exhibit, so it's going to be, I don't know whether it's part of what Mr. Chick gave me as the exhibit. Try to backtrack through the emails to see if it fits in the chain. I have all of the email chain.
Okay, first document I'd like to ask you about is in the stack. I believe that's stapled. It will be about midway through the stack, and it is from Brian Reynolds to you. And it has, looks like this, has number 1 at the bottom. Okay, if you would flip through your stack and maybe find this. It's from Brian Reynolds, dated Friday, November 15th, 3:24 p.m.
Judge, is it okay to use his unentered documents as exhibits? These are not entered as exhibits.
Is this what was given to me before? Yes.
Yes.
Okay.
They're okay to go
Yes,
through?
it is.
Okay. What page?
It's about midways in the stack. It's dated Friday, November 15th, 2 days after I took the course at 3:24 p.m.
Your Honor, I'm going to object to relevance. The charges that this is not what the notice of hearing and charges alleges. Now he's talking about documents, things that were sent afterwards.
Okay. I think I found the one he's talking about, but
Your Honor, they introduced an affidavit from Mr. Reynolds. This is also a statement from Mr. Reynolds. It was sent to Ms. Avers, so they have notice of it. I just want to bring out one important statement that Mr. Reynolds made in addition to his affidavit, if I may. And
What's your objection, Mr. Chick?
My objection, Your Honor, is that the document that he's talking about now is not relevant because it's dated. It was completed after the incident that gave rise to the notice of charges.
Your Honor, if
And
that's
it
the
has
case,
no-
I'm sorry. Excuse me.
It has no bearing on the events that we hear about today.
Your Honor, I would object to that because this document was also dated after the course, so if his reasoning is valid, then his affidavit's also not allowed to be in here.
That you're speaking about, does it relate to the charges
Yes, it
for
does.
the board today?
Yes, ma'am.
It does?
Yes, Your Honor.
Okay, go ahead, ask.
Okay, you found that email November 15th at 3:24 PM?
I don't think I have that right time. I have 3:03 from Brian Reynolds.
Your Honor, may I approach to show her which one it is?
Oh. Show Mr. Chick, if you would, please.
Oh, I found it. I apologize. I found it. All right.
Thank you.
What were you asking?
Would you read the first sentence of the second paragraph?
First sentence of the second paragraph.
Yes.
I'm sorry, I can't recall the student's attendance, but that's not uncommon.
Okay, thank you. Then, Ms. Avers, if you would turn back 2 more pages farther, you will see a series of emails between yourself and myself. And the top of it is dated November 22nd at 1:20 p.m. Okay, and these read from bottom to top because the most recent email was at the top. So if you start at the bottom, my email to you at 12:09 p.m., would you please read the body of that email I sent to you, please?
Bottom it says, Mr. Cameron, I have your several responses and your education credit letters. You will have to wait for a legal decision on this matter. I'm not going to argue with you about your attempt to mislead.
I'm sorry, you're on the wrong page. Excuse me. It's this page right here.
That's the bottom of that page. I have all your emails and
Well,
your documentation.
I'm sorry, Ms. Avers. I'm talking about the email from me to you dated November 21st at 12:09 p.m.
And that's right above that one.
Okay, excuse me. On my page, it's at the bottom of the page.
Please find attached uniform request form properly filled out by the Columbia Institute and countersigned by me. I'm not trying to be argumentative, just stating my perspective. I will be happy to provide hard copies if requested.
Okay, now then, would you read the response that you made to me at 1:41?
Mr. Cameron, I have received the same previously. I don't need hard copies or any more copies. You will have to wait for a decision on this complaint.
Okay, and then would you read my response to you at 1:20, please? On November 22nd, the following day.
Ms. Avers, begging your pardon, but I had not sent the uniform request for credit from Columbia Institute previous to yesterday's email, so I don't know how you could have received it already. Also, if your intent is to not renew my license pending a decision on this matter, I need to know as soon as possible so I may resign.
I'm sorry, you won't need to read the rest of that. I just meant for the first sentence there. So I sent you this uniform request on the 21st of November, the one that we just identified here that you have in your documents. I sent that to the Real Estate Appraiser Commission as official notice of the course that I took, as is required by Tennessee state law, fulfilling all the requirements of it. You told me that you already had that, and I asked you how you could already had it if I had just sent it. So can you explain that to me, how you obtained that if I hadn't sent it to you yet?
I already had the course completion certificate from Columbia Institute.
Okay, when
That's
you're
all we
talking
need for
about,
continuing
are
education.
you talking about the student transcript?
The course completion certificate is all that we need to post the continuing education.
Okay, I don't have a document entitled Course Completion Certificate. Can you show me that, please? What does it say at the top?
Columbia Institute student transcript.
Okay, it's a
continuing
student
education.
transcript, not a, yeah, I know I'm being argumentative, but I'm just,
It needs to let the witness finish.
Mr. Cameron,
answering.
if you ask her a question, give her a chance to respond, please.
This student transcript, as you indicate, has a certification on it that states, this is to certify under the penalty of perjury that the student
Won't
named
be
above
necessary.
has satisfactorily
Perjury.
completed the described course in accordance with the rules and requirements of Columbia Institute and the agency listed. The agency listed would be the Tennessee Board, because they do have the course number on there, number 1633. Satisfactory completion means having been in attendance 100% of the scheduled time and having completed all required lessons. And for distance learning courses, the student satisfactorily completed all lessons for appraiser qualifying course credit. Satisfactory completion also means having passed with examination. School official, Virginia A. Cox.
thank you.
That's what's required.
I'm sorry, I beg to disagree with that. What's required is what the state law requires, not what Columbia Institute provides, Ms. Avers.
And all of the other continuing education that you've submitted throughout the years was disqualified also, because that's what you've turned in for all of your continuing education.
To the best of my knowledge, I've sent in uniform requests for continuing education credit. You know, if you want to show me that and make that a separate issue, you know, we can talk about that, but it's my understanding that state law requires this particular form, and the student transcript is not what's required by state law. And my question to you was, how could you have received my uniform request already if I had only then sent it to you?
Well, your initial email to me indicated that you were submitting your course completion certificate for continuing education credit and included the whiteout version. And you were submitting it on November 13th to obtain credit. So if it wasn't your intention to get continuing education credit, why would you have submitted it?
I'm not testifying here, but the simple answer is I was advising you as to what course I had taken pending receipt of the official uniform request. The two documents that I referred to, the course completion certificates, were in fact the uniform request that I did send for other courses. And you should have those in your file there, I would presume.
Your Honor, I'm going to object to I guess the way, it's confusing in the way that this is being presented, because I'm not sure if he's testifying as himself as a witness or if he's questioning Ms. Avers.
Mr. Cameron,
Your Honor.
since you call Ms. Avers as a witness, then at this point you need to ask her questions, okay?
Yes, Your
And
Honor.
then if you want to testify, then certainly you understand you may testify, but finish with Ms. Avers with any questions you have for her, and then you'll get a chance to testify, okay?
I appreciate that. She had asked me a question. Ordinarily, witnesses don't ask questions. I was simply trying to answer that. Perhaps I should ignore her questions would be the best thing, I guess. My apologies. Okay, when I sent in my request for continuing education credit, did I not have two other uniform requests for continuing education credit that accompanied the student transcript from the Columbia Institute?
You did.
Okay, would it be reasonable to assume that maybe those were the official documents I was referring to and not the unofficial student transcript?
I don't think that, I don't think you were excluding one of the three documents.
Okay, then I've got a couple other questions for you, and then I guess you'll be happy that I won't have any more. Did you put my renewal on hold?
I held it until we had a legal decision on the matter, and then I renewed your license.
And so how long was my renewal suspended or on hold?
It wasn't suspended, but it
Okay. Did you give me any written notice that you were going to suspend or put my license renewal on hold? Okay, on the paperclipped group again, an email from you to me. Sorry, I don't have a date on this. Bottom of the page, it's got the number 3. And that document, perhaps? It's immediately after this document from the Columbia Institute. Hey, would you read the last sentence of your email to me?
Renewal is on hold.
Thank you. If you will go then 1, 2, 4 more pages back. It's at the bottom right-hand corner. It says 1 of 5.
Sorry, which page?
I think it's, let's see. Be 5 pages past that. Has 1 of 5 at the bottom right-hand corner.
Okay.
You see the email to me? Says it's November 18th, 5:35 p.m.
Yes.
Okay, would you read the first half or to the first the first comma in the second sentence?
This email is to notify you that a complaint has been filed, has been opened pertaining to this matter. No findings have been made regarding this complaint, but all email exchanges are being added as information regarding the allegation of knowingly submitting false or misleading documentation in order to obtain renewal of your appraiser license.
Okay, so once again, I'll ask you, how long was my renewal on hold by you?
Looks like 3 or 4 days.
Joseph.
Your Honor, Siri was not on the witness list.
License was renewed before it expired.
It was on hold for several days, though. Is that not correct? Are you aware that you're not allowed to suspend or withdraw or revoke or otherwise not renew my license unless you have given me written notice by mail showing the facts, etc.?
I am aware of that, but your license was active through that entire period.
Is there ever any doubt that I altered that certificate or that student transcript? Forgive me.
Initially, there was a doubt as to who may have altered that certificate. There was never any doubt that the certificate was altered. That's why I asked you who altered it.
Did I ever deny having wiped that out and put my name on it? Did I ever deny that?
Yes, initially you blamed it on someone else.
Would you show me that document, please?
On page 8, you can see we had several phone calls that first day about the conversation, and I contacted both Gene and Brian Reynolds.
I'm asking where I specifically denied doing so.
Contacted them to find out what happened, because they said it was because when we first talked, attached is your transcript for the course completed. Miss Avers, Executive Director, she received a whiteout certificate and questioned if you were actually in class for her request.
So was there ever any doubt that I was in the class for the duration? Okay, so you have testified that I initially denied that. Can you show me that document, please?
Working on it. I know
Thank
you
you.
did. On November 15th at 11:24 a.m., it says, attached is a copy of my transcript. For some reason, it was not ready the day of the class, and the instructor had to give me a copy to put my name and information in. Here's the official version.
Okay, so does that state that I did not put my name and information in like you just testified that I did?
The instructor didn't give you a copy.
I was paraphrasing. Have you ever summarized a set of events?
The instructor didn't give you a copy to...
Well, I will testify to that after a while. Have you ever summarized a set of events?
Objection, Your Honor, irrelevant.
Sustain.
And on page 15, I asked you specifically, tell me how you became in possession of a course certificate with white in the name area and license information.
So I'm asking you again, do you have any document in which I denied ever putting my name on it?
Objection, Your Honor. He's asked the witness a question. She's looking for the information to respond to his question.
Mr. Cameron, let her find the answer.
Okay.
And you respond, here's the copy of the course certificate emailed to me absent my license information, which I've written in. There's no intent to fraudulently alter anything. Many classes hand out certificates that are pre-signed with the recipient's name. So, yes, I do think that that's skirting the issue on the, yeah, I did that.
Once again, do you have any document which I deny doing that? And if you would look at my response on November 15th at 3:07 p.m., do you have that? November the 15th at 3:07 p.m. in response to your question. Sorry, it has a number 3 at the bottom, and it's 1, 2, 3. Looks like it's 5 pages back in this stack that has, it's not the paperclip stack, it's Did you find that?
3:07 a.m. it says, or p.m. Miss Avers, I put my name and address in the spaces and used whiteout because coloring in the areas which would not have allowed the name and address to be legible.
So once again, I never denied whiting it out and putting my name in there, did I?
That's not why you had to use whiteout, because someone else's name was in those spots.
That's correct, and I admitted clearly that I had done so, correct?
after I indicated I already knew you hadn't received that from the student.
No, I believe I
Or
called
from
your
the
attention.
teacher.
Well, I'm not going to argue with that. Do you have a document that says anywhere that I ever denied having done that?
No, I have that information I have information here that says that you got that certificate from the teacher, which was false. And then you provided misleading by whiting out someone else's certificate that was not yours.
Ms. Avers, when you asked me if I had done that, did I not honestly answer the question that I had done that? I whited it out. I put my name on it. Was there ever any doubt when you received that that did not come from the Columbia Institute in that form? How would that be misleading if I admitted that I put my name on there and it was clearly whited out? How is that misleading?
The school hadn't provided that certificate to you.
Objection, Your Honor. He's just arguing. It's
So staying.
Your
Any
Honor.
other questions for Ms. Avers? I think she's answered. I see where you're going. I believe she's made that clear. That
Okay, well, Your Honor, I'm charged with specific items here. And I just wanted her to articulate exactly how I did those specific items that I'm charged with. And maybe if I could find the charges, I can get her to answer specifically to those, if that would be helpful.
need a break. You okay?
Okay, do you have a copy of the notice of hearing and charges in this matter? Okay. Under your causes of action, you have actually two counts here. They both appear to read identical to me. Can you explain to me what the difference is in the two counts? You submitted them before the commission, I believe, did you not, early on in this year?
I did not write the notice of charges. I'm just a witness in this case.
Okay, then who filed the charges against me? Okay, did you not bring this before the commission early in this year and ask them certain questions about this? Has this commission not heard information about this starting like in January or February of this past past winter?
All matters are put on a probable cause legal report, but the names are all taken off.
Okay, but this matter was presented to this commission for consideration.
Process for probable cause.
Okay, Your Honor, as a matter of course, whom would I ask then to explain the differences in these two charges, because they read identical to me? You know, I've got two counts against me, and I don't understand why there would be two and what the difference is.
Testify, you can tell the board why these charges, in your opinion, are not accurate.
Thank
Okay.
you. Yeah. Like I said, I apologize. I'm just a layman. All right, let me see if I have anything else. As a practical matter, Ms. Avers, when you say that you have a real estate license, so I presume you've taken continuing education courses. At the end of the course, generally you're giving a document that is signed by some official, and it may be blank in certain areas. As a practical matter, is it not most of the time the course attendee fills in that information?
Objection, Your Honor. No, this is not relevant.
Let's take a 5-10 minute break. Okay?
Thank you, Your Honor. I could use one too. I have no further questions.
Unless the board has a question for you, you're done. Thank you. Oh, you do, okay.
Is this whole thing over $100, Mr. Cameron?
Oh, it has to do with my integrity,
Oh, it
sir.
has to do with whether or not you're willing to pay $100 and talk to Nicole and say, hey, I've got this done, I'm taking it today, I'll send you the $100, I'll send you a thing as soon as I get through. Wouldn't that have solved the whole problem?
Yes, and I
It wouldn't
offered.
have gotten this far, would it?
I offered to do whatever they needed as far as what they required of me. All I was doing do I need to go on the record and testify and start direct or whatever? If he wants to question me instead of Ms. Avers? You want me to go ahead and answer his question then?
Go ahead and answer it.
Mr. Hall, yeah, of course I wanted to save $100, but I also offered to do whatever was necessary to, comply with whatever rules, and including pay them the $100 if it was necessary at a later date. When I gave this altered student transcript, in my mind, all I was doing was advising her that that was a course that I had taken that date, pending receipt of my uniform request for continuing education credit, which is to me is the official document, and which state law says is the official document. In my mind, all I was doing was telling her, this is the course that I took. I sent my other 2 uniform requests for continuing education forms in, and I had nothing else to show that I had ever even been in this class other than this little bit of proof that I had. And I was waiting for them to send me those documents. Had they done so, then I would have forwarded them right away. In my mind, I wasn't trying to mislead anything. I was in the class all day. I should have had my documents. I registered for the class early enough that they should have had it. I never even got my workbook. But to answer your question, yeah, I tried to save $100. I would have paid it had they required it of me. They never asked it after that. All I was trying to do was tell them that was a class that I had taken. In my mind, that's all I was doing.
Mr. Cameron, we all have 20/20 hindsight, correct?
Yes, unfortunately.
Okay. Let's go back then to your 20/20 hindsight. Don't you think this thing could have been solved if you'd attached a note, dear Ms. Avers, I have altered this transcript here. I was in the course. I am waiting to get it. I am going to send you the certified copy as soon as I get it. What I'm doing, I hope, is not illegal, immoral, unethical. Something to flag her other than letting it come through as if though I was there. This is what they gave me. I think that is the real contentious part we have right here. Not whether or not you intentionally did something wrong. I don't think you did. However, I also don't believe that you went far enough in full disclosure as to exactly what you did do, which is why we're here now.
I understand that, and let me point this out. I took this course. I also took a couple of other courses. I volunteer at the Tennessee Veterans Incorporated in Morristown, Tennessee.
Your Honor, respectfully, Your Honor, I would object. I think we're getting off.
I'd be happy to
He
go
is
on
getting
direct.
into his testimony.
Well, I'm sort of taking it as testimony. Is this your proof? Or is this your testimony? Because I
Well,
think you're done with Ms. Avers.
Yes, I'm done. Thank you, Ms. Avers.
Thank you.
Yeah, I'm done with questioning her. I have a witness that I would like to call, but I would be,
Pardon me, then, I thought you were through.
no, I'm sorry.
I apologize to the
Oh.
court, apologize to Ms. Avers. I thought when you said you were through, I took that to mean that you were through.
Oh, I apologize. No, man, I had no further questions of Ms. Avers.
No
and
problem. No problem.
And I certainly understand your concern there. If you want me to go direct or call my witness, I'll be happy to do either way. And maybe if you want me to go direct, maybe you can think about it. I'm going to have to call this witness, but that would be...
Well, go ahead on.
Okay. Well, let me just continue then as if this is direct testimony. This was a long day. If you look on my timestamp, it was, I had waited all evening for receipt of that email from them so that I had some kind of documentation that came from them other than Mr. Reynolds' permission for me to do so. And by the way, I have a witness that saw me obtain that, and I didn't just do this, okay? I asked Mr. Reynolds if he minded if I did this, and he gave me permission. I called him, this became an issue. He says he doesn't remember talking to me.
I object to that. That's hearsay. I object to that.
Your Honor, I'm sorry, Your Honor, there was an email from Mr. Reynolds in which he declared...
Anything that someone else says is hearsay, okay?
Well, we've already introduced his statement that he doesn't remember me, so I think that would be relevant. That was introduced a while ago. Mr. Reynolds stated in his email he didn't remember me. And when I called him and asked him about this, he said he didn't remember it.
Objection, Your Honor,
Okay.
hearsay.
Sorry. I'm testifying that that's what I did, okay? I asked for and obtained his consent to show some kind of proof that I had been there. Now, when I paraphrased it and said he had to give it to me, I wasn't thinking about I'm going to be here testifying under oath. Is that exactly what he did? You know, in my mind, I asked him if he had a copy machine. He didn't have one. And
Objection, Your Honor, he's still
Okay.
skirting
Excuse
around
me.
Nothing
hearsay.
someone
All right.
said is hearsay, okay?
Okay, all I can tell you is what I did. I asked him permission. In my mind, I can't say what he did, obviously, but in my mind, he gave me permission. Otherwise, I would not have done it. I'm not a dishonest person. But to answer your question, my email to them sending this in was about 10:30 or 11 o'clock Eastern time, my time. I had waited all afternoon, all evening, to see if they would send me the student transcript. But what I really wanted was my uniform request for continuing education credit, because I know, and we all know, that's what the law requires. To me, the student transcript was just something that you hang on your wall, you know, or put in your file because it shows you've been there. It was irrelevant. Anyway, I volunteered at the local veterans organization, and it was about 10:30 at night. I'd waited, didn't get it, hastily composed this email and sent it to them. In hindsight, being 2020 and what it is, yeah, maybe I should have said, I'm getting this pending the others. I was dead tired. It was late. I just did it. The next day, I tried to explain my actions. I never denied that I whited it out. I never denied that I put my name on there. And if you look at my email trail, I've never denied that. And if you want to read them all, as soon as she asked me the question, where'd it come from, I said I did it, you know. I've got, you know, in my mind, I did nothing wrong, and I still feel that way. I've been the course coordinator for numerous IRWA courses, and at the end of the course, they all hand out these uniform requests. I have never taken a course from Columbia Institute prior to this, but every other course that I've taken, at the end of the course, they all have these pre-printed and pre-signed uniform requests for continuing education credit. That's what I expected to receive. I didn't receive that. I had no proof that I was there, none at all. That's what I wanted. You know, if they'd given me that like every other course provider does, we wouldn't be here today. I would have filled it out and sent it in. Okay, so from a time standpoint, I was in the class all day. I went to lunch with the guy that sat beside me. It was a small class. We talked. When the class was over, I expected to get my uniform request for continuing education as is required by state law and is spelled out in the commission's on regulations. If you go to the commission website, that's what you download as proof, and it says right there on the form. Says right here on the form, State of Tennessee, Department of Commerce Insurance, Real Estate Appraiser Commission, uniform request for education credit. This form was developed for reporting continuing education to the Tennessee Real Estate Appraiser Commission. This form, not a student transcript. Like I said, got to the end of the class, I didn't get this. This is what I expected. Every course that I proctored or coordinated, this is what we give out. And I know you guys, most of you, if you're appraisers, you've done the same thing. You get this, you put your name and information in there. How is that any different filling in a blank one? It didn't come with your name pre-printed on it. You know, you picked it up at the end of the course and you put your name on it. Everybody trusts you. You sign it, stating that you were there. I didn't sign this other one. To me, it was irrelevant. All I was doing was just telling them, hey, this is the course I took. I'm waiting on this official document. Mr. Hall, I did not specify that at 10:30 or 11 o'clock that night. Hindsight being what it is, yeah, I should have said, hey, this is what I'm doing. We wouldn't be sitting here today, you know. That's my fault, okay? I accept responsibility for that. I also have accepted responsibility for doing what I did. I never denied it. She did not show one paper from me that said, hey, I did not white this out. I did not put my name on here, because I never said that. I always said I did this, okay? So at the end of the class, the student, we had a brief conversation. I was sitting there waiting to get this form. Didn't get it. I asked the instructor, I said, hey, where's my form at? You said, I need it.
Objection, Your Honor, hearsay.
Okay, I'm testifying to what I said. I didn't say what he said back. So
Say
is
what
that
he
still
said.
hearsay?
You can say what you said.
That's all I was wanting to do was say what I said.
Yeah.
Okay, I said, where's mine? I didn't get one. I had a brief discussion with the guy that sat beside me, you know, saying, well, you know, I really need this. Is what I told him. I said, I've got to renew mine today. I need some kind of proof I was here. At that point, I left my table, and I walked up to the instructor, who was hastily packing his bags to get out. And there were a couple of people standing there talking to him. And I said, I need my uniform request today because I need to renew tonight, online. I need to do that. He says,
Objection.
okay, that's right. He said, I'm sorry. He did not have one for me, okay?
Objection, Your Honor.
Only what you said, not what he or she said. It's
Okay,
hearsay.
I'll try to get that in my brain. I did not get anything from him. I asked him permission. In my mind, I got permission. Is that fair enough? Okay, I sought permission to do what I did. After I did that, I went back to I asked if there was a copy machine nearby. There was no copy machine nearby. Okay? Clearly, in my mind, the instructor knew what I was doing. I explained what I needed. I told him I needed permission before I did it. I can't say what he said, but in my mind, I got that permission.
Your Honor, he's still trying to skirt the issue
Well, all right, let's talk
He's
about...
still trying to get things in the back door by hearsay, by
Okay.
telling what
Same
he did.
position.
Thank you. Sorry, I'm not an attorney, obviously. Okay? May I speak about this affidavit? I have one comment to make about this affidavit.
Okay, make it.
Nowhere on this affidavit does he say he denied me permission to do what I did. He said you can read it. He says he never altered it. He never directed or suggested. He never says I denied him permission. Okay, it's not in here.
Set your proof.
Just one moment. Let me look at my record to make sure that I've got what I want you guys to understand. Well, just let me make a couple of statements here. If I'd intended to deceive, I would not have been so amateurish. I should have got a typewritten thing. I wouldn't have whited out and put my name on there. I mean, that's pretty obvious that I did that. I never denied I did that. There's no reason to, you know. The document, at least in my opinion, does not meet the requirements of the law. It's not the legal document that's required. I submitted the correct legal document once I obtained it. If they wanted another $100, at that point I would have been happy to pay them. Also know that Mr. Reynolds works for the Appraiser Commission, and some of his money comes from this commission in investigations and things. If I was him, I would not want to upset my apple cart. And I have a witness to call that can corroborate at least part of my testimony. And if you want to cross-examine me, I'd be happy.
Mr. Chick, you have any question?
Mr. Cameron, what time did your, did this class number 151 begin in Knoxville on November 13th?
I think it was 8 or 8:30. I'm not sure which.
8:30 a.m.?
Yes.
And what time did it finish?
About 4:30 or 5.
You took another course that same day, right?
Yes, I did.
What was that course? What was the other course?
I took an online course. I believe it was from McKissick.
Was that a 6-hour course?
I'm not sure how long it was.
I'd like to show you a document here.
Yes.
Tell me, does that help you answer whether or not it was a 6-hour course?
Yes, it was.
Okay, what time did you start this course, the 6-hour course?
As soon as I got home after taking the first course.
What time did you get home?
Approximately 6 o'clock.
6 o'clock. So that means you would have been on that course until midnight?
No, I finished that course early. I went through the entire course in less than 6 hours.
Is that legal according to the statutes and rules?
I've not seen anything that says it's illegal. I took the amount of time that was required to read the course and take the exam.
Did you certify that you had completed 6 hours on the online course?
That's the credit that I received.
But what time did you really get finished with it?
I'm not sure. Probably shortly before I emailed these transcripts, which would have been like close to 11 o'clock or so. So I'm going to say about 5 hours.
And you mentioned that you had also volunteered that day. What time did you volunteer?
I go to Tennessee Veterans in the evening, and I kind of oversee.
On this evening, I'm asking
Yes.
you, what time did you volunteer?
I went to the post there about 6 o'clock, and I got on their computer and got on my computer there at the post and did my continuing education course.
Okay, so you said earlier that you took the first course 8:30 to 4:30. I asked you when you got home, you said about 6, but you didn't go home. Now you're saying you went to the post?
Yeah, I don't recall exactly what time that I, went there, but I guess
Home before you went to the post?
probably briefly, yeah.
Okay, so you went to the post and you volunteered. What did you do while you were volunteering?
I took this course here. I say I volunteered there. I didn't have any actual responsibility I had to do that night, if you want to put it in a time frame. I got out of this class about 4:30 or so. It's about a 40-minute drive to my house, so I got home a little after 5. I spent a few minutes packing my computer and stuff. The post is about a 15-minute drive from my house, so I was there somewhat before 6, so I think it's fair to say I sat down about 6 o'clock and
So you
began
didn't
taking...
volunteer. You went to this place and used their computer.
Well, I do volunteer
Right.
there, and I'm on
Okay.
call if they have a
you got a
problem.
computer at your house?
Yes, I do.
I didn't get to
Okay.
finish.
I'm sorry.
Have you got a computer at your house?
I have a laptop that I take with me places.
Okay. Did you submit any kind of credit to this volunteer place saying how long you had worked there?
No, I don't get paid. I'm strictly a volunteer.
Okay. But wouldn't you agree it's a little bit misleading to say that you volunteered from 6 to 11 because you were really doing the online course, correct?
Well, I don't think that's misleading. What I'm saying is I volunteer at the local Veterans Court post, okay? In the course of my being there, I'm kind of on call if they have any problems or anything. I help with security. I help with problems if they have any kind of a problem. Okay, I went up into my office and I sat down and took this course as I was sitting there waiting to see if they needed me for anything. And yes, it calls for a 6-hour course, but it didn't actually take me 6 hours to take it. You know, I took it in the order that it was required, and I don't know exactly how long it took me, but a little bit less than 6 hours.
Okay, let me ask you about, you've made several references to the rules that require a certain form to be used. I want you to show me, direct us in the rule.
Okay, statute. Uh, 62-39-315, renewal certificate requirements. It says down at the bottom, the state certified real estate appraiser shall present evidence in the form prescribed by the commission. Then if you go to the rules of the Real Estate Appraisal Commission, you can go online.
Okay, slow down a little bit and
Okay,
tell
sorry.
us what rule number you're at now.
1255-01-11. License and certificate renewal.
Okay, which part of that?
Number 3, each application for renewal of a license or certificate shall be accompanied by sufficient evidence of having completed the continuing education requirement for renewal specified in the Act, this TCA, and the rules, and presented in the form prescribed in Chapter 1255-4 entitled Continuing Education.
Okay, so we're still looking for the form. So show me in 1255-4 then where that uniform form is required.
I don't have 1255-4 with me, but if you go on to the website, you download this form.
I do. Hold on. That statute you just read, it says specified in the act and the rules
Yes.
and presented in the form prescribed in 1255, right? Doesn't say anything about a website, does it?
No.
Okay. So if we go to 1255. -4. Okay, here's 1255-4-01. Show me in there where it prescribes a form.
I don't see it in this, but there's another section that says that the real estate commission will promulgate forms and procedures. It's like a catch-all.
What I'm asking you, Mr. Cameron, is you keep talking about this form being the holy grail form, that it's required. I'm looking for you, I'm wanting you to tell me specifically what rule or statute says that form is the form.
Well, it just says on the form that it was developed for continuing education credit.
Where does it say that? But that's not in the rule or statute, though, is it? What we're concerned about are rules and statutes. Cameron, there's nothing in the statute or rules that requires the use of the uniform request for education credit, is there?
It's my understanding that there was.
But if it turns out that you can't find it, would you agree that you were incorrect?
To that point, You know, all I can tell you is from a layman's standpoint, you go to the website, this is the format you get, and it says it was developed for reporting.
There's
And
no statute or rule saying that uniform form has to be used, is there?
give me just a moment, I'd like to finish reading.
This might make it easier for you.
Okay.
This version, you can search for the word form.
There's one thing in my favorite, says course hours defined as 50 minutes, so I could take a 6-hour course in less than 6 hours. Take 6 hours times 10 minutes, that knocks an hour off, so that puts me approximately to 11. I'm sorry.
Part of it.
Okay. Under the rules here, it says a course hours defined as 50 minutes of teaching out of every 60-minute segment. So the question was, how did I finish a 6-hour course in less than 6 hours? So take 10 minutes off of 6 hours, and that's an hour. So that
Mr. Cameron,
puts me
I
about-
don't think that really helps you in
I understand. I'm
instant
just-
quests at all.
Well, I'm just saying I apparently fulfilled the 6-hour requirement, even though I was able to do so in less than 6 hours. Okay, under license and certificate renewal, it says to obtain renewal, must make, oh, I'm sorry, that's on application of the form.
Your Honor, could I request that the court note for the record that the respondent cannot identify a statute or rule that requires the use of the uniform form so that we could move forward?
Yes, you may. We
Okay.
move forward.
That's all the questions that I have from Mr. Cameron.
Do you have any questions for Mr. Cameron?
Have any questions? Mr. McNary?
In your mind, it was your understanding at the time that you filled out that one form or doctored that one form that it was not the correct form in order to get credit for this course?
Yes.
Okay. Where did you get the form that you whited out, by the way?
I think I got that one from the neighbor that I got a set by, but I'm pretty sure that's who I did, but it was, all happened in kind of a hurry, and I just needed they didn't have a copy machine handy, and so I asked the instructor if I could make my own. Can't tell you what his response was, but I left with the understanding that that was permissible, and the only way I had to do that was take a picture with my cell phone. I have since deleted that, but the best I recall, it must have been the guy that I was sitting by because he was handiest to me.
Do you know of anyone else who has done anything like that in your experience with continuing education?
Not specifically taken a copy with a cell phone, but we've always made copies and given out these uniform requests for continuing education credit to anybody that needed one without any question. They all come pre-signed, and you fill in your information.
Okay, so it doesn't bother you that there was a signature at the bottom of the form that you whited out?
Oh, there's signature on all of these forms already. And so it honestly didn't mean anything to me.
Including the transcript forms already have a signature on them?
Yes, these uniform requests for
No,
continuing.
I'm not talking about the uniform request for transfer. I'm talking about the student transcript.
Yeah, it's unit
That-
transcript, yeah.
Okay, and they have a signature on them already?
Yes.
Thank you, Your Honor. Mr. Cameron,
Yes, sir.
did they have two documents? One was the student transcript, and then one was the uniform request for education credit. Did they have both of those documents at the class?
No, sir, they only had the student transcript.
Okay, so there wasn't the uniform request handed out at the same time?
No, sir, I obtained that through the Columbia Institute at a later date.
Great. Howard?
In the information you sent regarding 1255-01-11, item 4, item 3 that you keep referring to in regards to the Act and Chapter 1255-4, the first line of that actually says, accompanied by sufficient evidence of having completed the course. Just a general question, would a student transcript have sufficient evidence that you completed a course?
Not in my opinion, because it says in the form prescribed. Now, I'm not an attorney, but when you go on the web page, this is the form that you download, and it says it was developed for reporting continuing education. So as a layman, this to me means what it says.
Questions from the board?
Cameron, you said you have another witness?
Yes, the gentleman that sat beside me in the class, since, this is a real question here. He saw what I did. He will testify that he sat beside me in the class all day, that I was there all day. We went to lunch. I did not know him prior to the class, haven't known him since, obtained his information because I remembered he worked for Farm Credit Services, who he told me he worked for. I've not discussed anything about doing business with him. He offered to send me, work during the course of the class because, well, I'd be presumptuous, but he was impressed by my knowledge and his perception of my integrity.
So what is he going to testify to? That
He's going to testify, if necessary, that he had a brief discussion with me over my need to have my continuing education credit form, and that he saw me go up after they were all handed out and discuss it with the instructor, and at least his impression was that what I did was not prohibited, or that I had permission to do what I did. That would be his testimony. If you want to call him or stipulate to that.
Sure, we can dial them up right
Okay,
here, Your Honor.
okay.
If you'll just pass the card down.
Sure.
we'll,
I think you can call him on his cell phone here.
No, on the,
I know. Card.
You've reached Neil Niles' voicemail at Farm Credit. I'm unable to come to the phone right now. Leave your name and a number, and I'll call you back as soon as possible.
All right, thank you, Ms. Davis. Well,
I did give him a subpoena, and I think he was expecting us to call him earlier in the morning. I don't know what time it is, but it's obviously not morning anymore.
okay. Well, then that concludes your proof.
Can you leave a message to, I don't know how long it might take him to call back, if just advise him that it's the commission, maybe give him a couple of minutes?
We'll try again, Your Honor.
We'll try one more time.
Call the other number.
Would leave a message on his cell if possible, just tell him it's the commission, and would he call back? Maybe he doesn't know the number or something, I don't know.
Is there more than one number on there? If there is, I would try all of them.
Yes, sir,
I think
there's
he's
an
right.
office number, I think, and his cell number.
Farm Credit Mid-America, this is Janice. Can I help you?
Is Neil Niles available?
Neil, he is out of the office right now at a meeting. Would you like his voicemail?
Yes, please.
Okay, just a moment, please.
Are you thinking about building added grain storage or a machinery shed? If so, Farm Credit can help you get acquainted with leasing as a financing option. Take advantage of Farm Credit's deferred lease payment offer on grain storage, machine sheds, and storage buildings, and until November 2014. Ask your financial
Farm Credit Services, you have reached Neil Niles' voicemail. I'm in the office today, but currently unable to take your call. Please remain on the line to leave a message, and I'll respond to your call as soon as possible. Thank you, and have a good day.
Record your message at the tone. When you are finished, hang up or press pound for more options.
Mr. Niles, this is Nicole Avers at the Tennessee Real Estate Appraiser Commission. We're calling in regards to that formal hearing. If you get this call in the next few minutes, our phone number here is 615-532-8679. Thank you.
Thank you, Ms. Davis. Okay, we're going to proceed, Mr. Cameron, okay?
Okay.
Mr. Chief, do you wish to make a closing statement?
Yes, Your Honor. Ladies and gentlemen, now, Your Honor, I do have proposed findings of fact and proposed conclusions of law, so is this appropriate time, Your Honor?
Yes,
or-
it is.
Okay. Mr. Dennis, could I? Ladies and gentlemen, the proposed findings of facts and conclusions of law come pretty much, they're a copy and paste from the notice of hearing and charges. And the state submits that you'll be able to, when this is turned over to you, you'll be able to go through the proposed findings of fact one by one, and I believe you'll see that the state has introduced proof that goes far and beyond each of those allegations. And then once you've done that, the state believes that you'll be able to take the proposed conclusions of law, and basically there are two counts in there. The first count alleges that based on let me ask this. Do the proposed facts, do they have 3 pages on your?
I has 2.
Does anyone have 3? It looks like what I've handed out is actually Okay, I apologize, but what I've done is I've left off a page in the proposed findings of fact and conclusions of law, but luckily, since it does come pretty much copy and paste from the notice and charges, the state submits to you that you can take the notice of charges and you start, if you were to start with the allegations of fact, you could go through each of those items. You'll see that the state has introduced proof to establish each of those alleged facts. And then if you move to the causes of action, you'll notice that there are two counts. The first count is that the respondent procured or attempted to procure a license by knowingly making a false statement or submitting false information. And as it says, that's based on allegations of fact 14 and 15. So in other words, the fact that, or the alleged fact that the respondent submitted the altered document in order to effectuate his renewal, that supports count one. And then you'll notice in count two, that in effect is saying that the alleged fact number 16, which is that he was dishonest in his response, that's what makes up count two, is his dishonest response, and I'll speak to those in a little bit more detail. The issue in the case is simply, it's an issue of honesty or dishonesty. Look through the exhibits, if you will notice, we can start with the ones that have the Bates numbers. I want to direct your attention to the second page, the student transcript. And I want to point out what it is that the respondent did exactly. There's a statement down there that says, "This is to certify under penalty of perjury that the student named above has satisfactorily completed the described course in accordance with the rules and requirements of the Columbia Institute, and that said and any agency listed. Satisfactory completion means having been in attendance 100% of the scheduled time and having completed all the required lessons. And for distant learning courses, the student satisfactorily completed all lessons. For appraiser qualifying course credit, satisfactory completion also means having passed with examination." And the important part of that is that it has a school official, and it's signed by Virginia Cox, who is the registrar of the Columbia Institute. So the point I want to make and leave with you is that by rules, these schools are required to maintain these records and certify that this student has attended this class. So the respondent can tell you all day long, well, it was just to show you I was there or that, but the fact is, by whiting this out, he took over the duties that belong by rules and statute to the school. That is a specific duty that the schools are required to certify. If there's not a certificate that was available for the respondent at the end of the class, then the school is not going to be prepared to issue that statement. And they weren't prepared to issue that statement. And I also want to point out that the respondent, he talks about everything is altered. Well, everything is not altered. The respondent doesn't seem to understand the difference in filling in a blank as opposed to erasing and covering up what's already there and writing in new information. If you think that filling in a blank is altering a document, then true, everything is altered, but the rest of civilized society understands the difference. As far as the count two, what was dishonest in his response? Well, at first the evidence has shown that he stated, oh, the course instructor handed these things out and we had to fill in information. And he's not honest. He comes along later and says, well, I took a photograph of a student's transcript. So not only was the first act dishonest, but the second act was dishonest. And I suppose the thing that the state notices the most is, as he stated himself, he said, I did nothing wrong. And that's troubling, because for a licensee of this board who has such an incredibly important job, to not be able to understand that what he did is wrong, that is a problem. And if we look at, the judge will instruct you as to the law and the rules, but one of the things that the board should consider is, if you agree that there's been an infraction, when you decide what discipline should be imposed, I submit the board should consider what is necessary to deter him. What are the circumstances? And quite frankly, I think the respondent still does not get it. Initially, I might have suggested, well, a civil penalty is okay, but to be honest, at this point, I think the respondent, this case would support and needs a 30-day suspension, in addition to a civil penalty of $1,000 for the first one and a civil penalty of $1,000 for the count two, and also cost of the hearing and investigation. All noted earlier, this is for $100. I mean, all this was done for $100. So I think the evidence shows that something's not clicking here, and the board needs to make, I submit that the commission needs to make clear the importance of this by assessing, again, a suspension, a total of $2,000 civil penalties, and all cost of hearing. Thank you.
Mr. Cameron, would you like to make a brief closing statement?
Yes, I would. Well, just like you said, this is about honesty or dishonesty. All my life, I've tried to be honest. This goes to the intent. Did I intend to mislead? No. And I take issue with his item number 16 or whatever it is, or number 12. In response to his inquiry, I provided an untruthful and misleading response. That's not correct. I state right here, first time they asked me, I said what I did. I put my name and address in the spaces and used whiteout. So there's nothing misleading or evasive. I never evaded any of their questions. I asked them, I answered them as truthfully as I possibly could at the time and under the circumstances. My choice of words may have not been the best when I was paraphrasing what had transpired between myself and the instructor at the end of the class. I said he had to give me one. He didn't technically hand me one, but he gave me one by his consent, and I did obtain that consent.
Your Honor, I hate to object during closing, but that's not been proven. He can't include things in closing that have not been proven.
I was unable to put on my witness, so I understand where he's coming from. I'm just telling you, I'm sitting here under oath, and I'm telling you that that's what I did. I don't get student transcripts from other course providers.
And I apologize, Your Honor. I have to object one more time to remind Mr. Cameron that he can't continue to testify now. Got to only comment on what's already been introduced.
Yeah, it's just a closing, okay? Everything, you've already testified.
That's what I thought I was.
Just wrapping it up.
That's what I thought I was trying to do, was summarize it from my perspective. You know, I don't understand that detail. I would just send my other course providers, don't give me a student transcript. They give me this document here. So I wasn't expecting that, okay? once again, this goes to honesty or dishonesty. Sit there and look at me before you. Do you honestly think that I would forge a document, which is what they're basically saying that I did without someone's permission, given the magnitude of what the occurrence is? In my mind, I had permission to do what I did. I sought the permission from the instructor, and he says, I don't get it. Well, I do get it. He offered consent. I wouldn't sign a consent because I felt I did nothing wrong, and I still feel I've done nothing wrong. So I either get it or I don't get it. In my mind, I did what I did with permission. I did not intend to mislead anyone. I answered their questions as honestly and straightforward as I could each time they asked me. I never denied doing what I did, and I'm not denying it here today. And as far as their civil penalties and that goes, you know, that's a drop in the bucket compared to the slap of me being found to be a dishonest person, because that's, in my opinion, not the case. Thank you.
The board now has 4 things to vote on: the findings of fact, conclusions of law, discipline, if any, and policy. If you'd like for me to read you the charge on each, I will. Or you may already. Would you like me to read the charge on each one? Okay. Under findings of fact, in making findings of fact, you must make your own evaluation of the testimony given by each of the witnesses and any documentary evidence admitted. You must then give that testimony or other evidence the weight and credibility that you deem proper. You may weigh the evidence in light of your own training and expertise. Conclusions of law. Once you have made your findings of fact, you must decide if the respondent's activity constitutes a violation of departmental or board rules or state statutes as alleged in the notice of charges, and if so, you must state those determinations in your conclusions of law. Your decision must include sufficient analysis of the evidence to clearly demonstrate how the facts of the case support your conclusions. Your conclusions of law should make appropriate specific references to your findings of fact to articulate linkages and connections between the 2 sections of your final order. And let me remind you that the burden is on the state in this matter, okay? A disciplinary action. If you decide that there has been a violation of a state statute or rule, you must then decide whether the disciplinary action taken by the state or the state is suggesting is appropriate in accordance with your legal authority and considering the particular circumstances of this case. You may affirm the state's action, or you may decide an alternative disciplinary action, or none at all, if that's appropriate. You may consider any evidence that the parties have introduced on the issue of the appropriate disciplinary action. And then finally, on the policy reason, a policy reason must accompany your determination to state why the decision you render in this situation is appropriate. Your policy reason is your statement explaining why the particular disciplinary action you choose in this case is correct, given the wide range of cases you hear and the various disciplinary options you have. And secondly, your policy reason tells the public and reviewing courts why the disciplinary action you choose in this case is proper, even though it may be a little different from what you have done in past or may do in future cases. The gravity of the violation and the respondent's attitude toward the action may be included in your policy statement to support your disciplinary action. This is just a short statement as to why the disciplinary action you have chosen, or you may not choose any, is correct. So with that said, I'll turn it over to the chairperson.
Thank you, Judge Ball. The state has put on the proof, and the respondent has put on his proof, and we've heard the 4 items that we have to discuss and decide. 1, findings of fact. 2, conclusions of law. 3, disciplinary action, and 4, policy reason. So there will be 4 separate motions brought forward, in 4 separate votes on those. And so we'll start with the findings of fact to begin with. And we have, in the notice of charges, there were, I think there were 16 findings of fact. And in the, with the applicable statutes that followed that, in the state's proposed finding of facts that he handed out separately, there was 12. So I'm not sure which ones have been left out and which ones haven't. So I think what we're going to do is we're just going to take each one of those one at a time. And, because they're pretty straightforward. I think it'd be easy to I'm sorry, there may be 12, the numbering may be off. Go ahead.
No,
Mr. Chairman?
Yes, sir, you're recognized, Mr. Hall.
Thank you. Your Honor, notice in reading the finding of fact about the first 9 are pretty straightforward and really not subject to a whole lot of discussion. Would it be permissible to make a motion for the board to consider that the first 9 be adapted as a finding of fact,
Yes, sir, that's fine.
rather than going through 9 different
Yeah,
things?
you don't have to go through each one.
Mr. Chairman?
I would entertain that motion. I think it would be important to let the record reflect what those are, to know that they're more basic type things, are not actual acquisitions. I mean, it refers to when the respondent was originally licensed and his license number. I mean, those things are kind of non-disputable. So I think as long as we're all agreeable to that, I'm happy to entertain that.
And actually, Mr. Chairman,
Yes, sir, you're recognized, Mr. Collinsworth.
only items 14, 15, and 16 in the allegations of fact are the only ones that, if I'm correct in that, Mr. Chick, items 14, 15, and 16 are the ones that have.
Let me, the state's proposed finding of facts lists 12 items, and and I just double-checked that with the notice of charges. The numbering begins on number 5 with the notice of charges, so there are actually 12 there. So
I got
they're
you.
the same, it's just the
Yep,
numbering is
paragraph
different.
number's wrong. Good,
So-
okay.
So I think we're
So
talking
it would be 10,
about.
11, and 12. So you all right,
Yes, sir,
Mr. Hall?
10, 11, and 12.
Yep.
So I think, so I believe taking 1 through 9 would be appropriate.
Your Honor, do you think it's appropriate to read into the record each one of these allegations, or just say we'll adopt 1 through 9?
I think Mr. Chick wants to.
Yes, Your Honor. Actually, I might not have been clear, but on the proposed findings of fact, I inadvertently left off 13, 14, 15, and 16, so I had suggested that you use the notice of charges, use those 16 items as the state's proposed findings of fact, even though they'll be numbered 5 through 20 or
5 through
21.
16.
May I ask a question of Mr.
Yes,
Chick?
sure.
Because he's referring to them in the causes of action, as numbered such.
I guess my question is, as I look back on these, if I compare, for instance, item 16 in the notice of hearing and charges, item 16, which would refer to count 2, more or less, is identical to item 12 in the state's proposed allegations of fact.
I believe the reason, Mr. Chick, you're wanting us to use the ones numbered through 16 is because the conclusions of law also reference 14, 15, and 16.
Right,
Right.
the state would prefer that you just disregard its proposed findings of fact and conclusions of law, and instead just go what's in the notice of
Start at
charges.
number 14.
So with that being the case, then if we wanted to consolidate some of these allegations and findings of, allegations of fact, which would become findings of fact in the motion, we would look at consolidating numbers 5 through 13. Is that correct?
Correct.
Okay. All right. Now, the question, do we need to read those into the record? Or referencing those, will that be adequate?
I think you can just reference it.
All right. Do we have a
Mr. Chairman, I make a motion that we accept as an allegation of fact items 5 through 13 as shown on the notice of hearings and charges and allegations of fact.
It's listed as allegations of fact, but technically it's findings of fact in terms of the motion. So we have a motion from Commissioner Hall to accept items 5 through 13 as findings of fact in this case. Is there a second?
Second.
I have a second from Commissioner Walton. Any discussion on that motion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Okay. Motion passes. So items 5 through 13 are considered findings of fact. All right, let's take the next three individually, if we will. And that would be number 14, that says on November 13th, 2013, respondent made a copy of another student's transcript, placed corrective fluid over the student's name, address, and license number, and printed respondent's own name, address, and license number. That's the allegation of fact, and we're charged with determining as to whether or not that's a finding of fact.
Chairman,
Mr. Hall, you are recognized, sir.
I move that we accept this. Both the state and the defendant both have, in my opinion, said and proven this over and over. Both parties have almost agreed, shall we say, to this particular charge. Accept that as a finding of fact.
And I'll second that.
We have a motion from Commissioner Hall, seconded by Commissioner Collinsworth, to accept item 14 as a finding of fact. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Okay, item 15. On November 13, 2013, at approximately 9:30 p.m., respondent delivered the altered certificate to the Department of Commerce and Insurance as an email attachment for the purpose of renewing his license. Same process here. That's an allegation of fact, and we need to determine as to whether or not we concur that that is a finding of fact. Mr. Hall, you are recognized, sir.
Mr. Chairman, I would appreciate a little bit of discussion on this, because what I heard was one party said that was not for the purpose of renewing the license because that was not really an official transcript. The other side said it was submitted as an official transcript. I would just like for the commission to consider this one and decide what they feel.
Thank you for that, Mr. Hall. Judge Ball, is it appropriate for us to discuss this issue?
Yes,
Okay.
absolutely.
All right. That's a good question, Commissioner Hall. And as I was trying to sort through some of these email correspondence with regards to that, as well as some of these other issues, I was trying to find the very first initial email that was ever sent, and for some reason I didn't have a date and a time stamp on that, but I do remember seeing a conversation saying attached or something for the purpose of renewing.
Well, if you look on November the 13th at 9:27 p.m.
Mr. Hall, would you look at the very bottom right-hand corner and identify the page number? Okay,
Number
all right.
one.
That'd be it.
It says that from Roger Cameron to the commission, hello, I am renewing my appraisal license number CG 426 and wish to send the certifications of completion for classes I have taken for continuing education. I did not find a way to send them on the website when I paid my renewal. Please advise if you need hard copies. Included in that is the certification where the student transcript where it had been altered.
I am assuming that these 3 documents were the attachments. Okay.
So the question is, on November 13th, 2/13 at 9:30 PM, Respondent delivered the altered certificate to the Department of Commerce and Insurance as an email attachment for the purpose of renewing his license. Is that, as I read that, though, it almost appears to me that that would be the reasoning, but
Chairman? It says that he was sending the certificates of completion for the classes he has taken for continuing education. It doesn't say what the purpose of that, other than to demonstrate that he had taken the class.
Any other discussion on that?
Yeah, I do.
Commissioner Walton, you're recognized, sir.
The whole, I think, motivation here that started this whole chain of events was to save $100 by renewing as of the date. So I think that's a clear intent right there. The intent was to renew and save $100. His own testimony has said that. And I believe we've recognized that the fact is he submitted an altered document. So in my mind, there's no question that the intent was to renew.
Well, when I read the email, you pay the renewal fee and then you submit the experience separately. They're not done together. And so the renewal was paid on site, paid through the website. And I don't know what time it went through, but the 30-day ticker was midnight on the 13th. And so there would have been nobody in the office when this email was even sent with the attachments to it. By the way, if I'm thinking correctly, going forward, this is a moot point because you can submit experience all the way up to renewal time going forward. So this is something that's not even going to be brought forward in the future. But
I would like to propose we accept item 15 of the allegations of fact as it's written. There's sufficient evidence to support that.
we have a motion to accept item 15 as a finding of fact from Commissioner Collinsworth.
I'll second.
And that is seconded by Commissioner Walton. Is there any further discussion? Is there any discussion on this motion?
The only thing I'd like to discuss, and I don't know if we're going to go back to it or not, is I don't know why I didn't pay, or we didn't pay even during the trial, more attention to that very first page that is an email from Mr. Cameron saying, I'm renewing my license and wish to send these certificates of completion for the classes. And this transcript is one of the three, which basically says at that point, he's saying this was sufficient enough. So I don't know if we'll bring that up again or not, but
Well,
I just wanted to mention that.
At this point, we're looking at strictly findings of fact, and then next would be looking at, after that, conclusions of law. And actually, as I read through this, that's where I have more questions than anything, is in the conclusions of law, section count 2, more so than this, these factual things on the front end. But is there any other discussion as to the motion on the finding of fact for item 15? If not, all in favor signify by saying aye.
Aye.
Any opposed? Okay. That is considered a finding of fact. Item 16, on November 15th, 2013, in response to an inquiry by the Commission's Executive Director about the presence of correction fluid on the certificate, the respondent provided an untruthful and misleading response. Okay, that's one I'd kind of like to talk about a little bit. does anybody remember where in this email chain that an untruthful, misleading response was typed? Because I
don't
couldn't see
recall him actually
it. Do y'all remember seeing that?
being untruthful.
Because I thought he admitted to the, what he did. So I was wondering, was there, okay, what page is that? That says page 019. Okay, that's 19.
Oh, shoot.
Okay, that's,
Well,
that-
on the.
which part of that, at the bottom?
Well,
Okay.
It's the other collection of paperwork, Mr. Hall. It's gonna be the.
19.
Okay, so
Nope, you're.
is
false statement.
is this, the statement where it says the instructor had to give me a copy and put my name and information in it, that's the untruthful, misleading, is that what we're alluding to because of the photograph?
Well, the
Instead of-
question asked is, in response to an inquiry about the presence of the correction fluid.
Where is that?
That's item 16, I'm sorry, in the allegations that were, the question, or the fact that we're discussing says that it should be about the presence of correction fluid on the certificate.
That's what see, this statement on 19 references the instructor giving a copy and putting a name in it, whereas you're right, Mr. Collinsworth, you're talking about the presence of corrective fluid and I read an email where he indicated that's what he did, but I was trying to find the email preceding that would indicate why that was brought forward, like something doesn't look right here or what's going on. I just never did see that. And on item 13, page 13, at the top, there's an email from Respondent at 3:07 p.m. that says that, Ms. Avers, I put my name and address in the spaces and used whiteout because of the coloring areas. Well, not, now, so I mean, he's clearly said what he was doing. So I'm wondering, was there something prior to that email that was misleading?
Well, I think the reasoning he
missing
gives for using the whiting fluid in that statement is misleading.
That's what they're referring to.
Well, is that the first email of that chain? 307, 325?
He doesn't say because it's got someone else's name on it. He says because the coloring made it
Now,
illegible.
wait, the one before that at the bottom is at 11:24 a.m. on the same date. And then there's a 12:12 from Jenny at the Columbian Institute. Let's see.
The sticking point is here, the instructor had to give me a copy to put my name and information in, whereas by testimony, all parties involved, that did not occur. What happened was the instructor gave him permission in his mind anyway to copy somebody else's and put in the name, but at no time did the instructor give him a copy to put his name and information in. Based on his email of November the 15th at 11:24 a.m.
I think Mr. Walton was correct on page 13 at the top. It's the reasoning behind using the whiteout is what.
Well, okay, that email came after the 11:24 a.m. email.
Right.
where Mr. Cameron had sent to Ms. Avers, attached is a copy of my transcript. For some reason, not ready to go as a date of class. Instructor giving me, I'm sorry, I'm going too fast. I apologize. I'm not going to read all that. It just,
Good.
that email. And then Mr. Cameron responded back, attached is your transcripts for the course you completed with us. Miss Nicole Avers has been in touch with us. And that's coming from the Columbian Institute. So there's the breakdown somewhere in there, and I'm not exactly sure where it starts and stops.
I think the overall question is regarding the top of page 13, the email at 3:07 PM.
Johnstone, that was in response to an email from Ms. Avers that says how you came to be in possession of a course certificate with white in the name area.
Right.
And license information, and he responded, I put my name and address in the spaces and used whiteout because of coloring in the areas which would not have allowed the name and address to be legible.
So therein lies the question, how is that untruthful and misleading when she asked him about it and he told her that?
Well, because there was actually a name that was underneath there that would have been legible without whiteout.
Well,
That's what they're referring to.
how you
Why'd you use the whiteout? Oh, because
came in possession of a
it wouldn't have been legible without it.
Well, that's a true statement, too.
Yeah, I mean, this one's the one that's, it's a little bit hard for me to sink my teeth into. I mean, I can see it both ways, really.
I mean, he was admitting to have done it, so he
I
wasn't.
mean, I think if he had just made a phone call on the front end and said,
Right.
you know, I took this class on such and such, the instructor didn't have it ready, what should I do? We wouldn't be here today, in my mind. But I mean, do I believe that this was an attempt at all-out fraud? We're gonna take some, I mean, I just don't see it.
Are we going beyond what it is we're supposed to be
Well,
deciding
that's,
right now?
yeah, I mean, that's what I'm saying. The
the,
question is, provided an untruthful and misleading response. So, part of that is, I've got to try to, in my mind, figure out, in his mind, was he being untruthful, misleading, or as I read this data right here,
I don't know if we've got enough to say that, because it,
Well, to me, on the facts of the case, when you read, we're on this page 13, you read the email from the defendant preceding the top one that's highlighted. Hello, Ms. Avers, attached is a copy of my transcript. For some reason, it was not ready the day the class instructor gave it to me. Put the copy of the information in. Here's the official version, blah, blah, blah. All right, that's not what I'm looking for.
up to the top.
no,
Right.
that's, these
Yeah,
two are the
yeah.
we're dealing with. That's just to somebody.
I put my name and address in the spaces and used whiteout because of coloring in the areas which would not have allowed the name and address to be legible.
I mean,
Right, and in his email previous to that, his first response is that the instructor gave him one. Well, that's not true. Then it's followed by this one where it's, I used whiteout because of the coloring, the name wasn't legible. Well, no, it wasn't his name. And in my mind, that's just not true.
where did you see the instructor gave me one?
That was
That was the page 19.
On 19.
13, it's on
I
page
think it's
13.
elsewhere
It's on
in here
page
as
13
well.
On
also.
19.
Oh, yeah, it is at the bottom of 13 as well. So you can stay on that same page.
Okay, what time was this one?
11:24.
No, it's 4:42. So that was November 15th, 4:42,
No,
which was after this conversation.
Right here. Right there. 11:24 a.m., that's
Was
it.
it on here too?
It's a cut and paste. Yep.
Where- where does
Hello,
it
Miss
say?
Avers, attached is a copy of my transcript.
Yeah, but it doesn't say the,
For some reason, it was not ready the day of class, and the instructor had to, that's the same one,
To give me a copy of,
to put my name and
oh,
information.
and he gave me a copy, oh, yeah.
that's just a false statement right there, in my opinion. And
But the-
then I used whiteout, which followed up, his next statement is, I put my name and address in the space and used whiteout because of the coloring. in these areas, which would not have allowed the name and address to be legible. That's just, in my opinion, that's false.
I don't necessarily know, as Mr. Hall commented a minute ago, in an odd sort of way, that's still true, because if he hadn't have done that and he had just written it, you might not have been able to read it. However, I do feel like that's a misleading response.
Yes.
I think it's misleading in the sense that the statement was made that he was given that by the instructor, when subsequent testimony has said by his own admission he didn't. The instructor did not give it to him, that he took a picture of it and then filled in his name. So that's the part that I have trouble with.
Can we
It just
make
lacks
a proposal
credibility.
to revise a comment? I would like to propose that we change the last portion to say the respondent provided a misleading response.
Take out untruthful and just take out,
Take out an
just strike in untruthful, and the respondent provided a misleading response. I think we can certainly do that if we'd like. So, as that would read, on November 15th, 2013, in response to an inquiry by the Commission's Executive Director about the presence of correction fluid on the certificate, the respondent provided a misleading response.
Correct.
Got a motion to that effect?
So moved.
Commissioner Walton moves to
Actually, I made the
Approve that.
motion, and he would be.
Oh, did you make the?
I made the motion to change it.
Okay, let's, is there a second for the motion?
Second.
Okay, Commissioner Collinsworth made a motion. Sorry, been a long day. Made a motion to revise item 16, and it was seconded by Commissioner Walton. Is there any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Okay, that is considered a finding of fact. That concludes part one of what we are doing here. The next item,
Chairman,
yes, sir, your
can we
recommendation.
take a very short break?
Yes, 5 minutes.
Thank you.
I'll take part of it home.
We'll talk about it. Okay, we're back on the record, and it's about 2:44. So we're ready for item 2, conclusions of law. And what we're charged with now is, once we've made our findings of fact, we must decide if the respondent's activity constitutes a violation of departmental or board rules or state statutes as alleged in the notice of charges. And if so, we must state those determinations in our conclusions of law. Our decision must include sufficient analysis of the evidence to clearly demonstrate how the facts of the case support our conclusions. Our conclusions of law should make appropriate specific references to the findings of fact to articulate linkages and connections between the two sections of our final order. Does that make sense to everybody? Okay, let's see. Judge, can I ask you a question? Would that be the causes of action? Is that the same thing?
No, you should have that.
I mean, is that going to be, but part of those are related, though. The causes of action and the proposed conclusions of law seem to be somewhat similar. Okay. All right, the states, okay, on item, we'll deal with item 1 first. And item 1 states the respondent's conduct as set forth And findings 14 through 15, or 14 and 15, constitute a violation of the following subsection of the Tennessee Code annotated Section 62-39-326. Item 1, procuring or attempting to procure a license or certificate pursuant to this chapter by knowingly making a false statement, submitting false information, refusing to provide complete information in response to a question in an application for a license or certificate, or through any form of fraud or misrepresentation. And item 4, an action or omission involving dishonesty, fraud, or misrepresentation. That's item 1 of the conclusions of law. And that goes with 14 and 15, and that's count 1 of the causes of action in the notice of charges. It would be similar to that. And relating back to 14 and 15, which we have already voted and found to be a finding of fact, is under 14, that on November 13th, 2013, respondent made a copy of another student's transcript, placed corrective fluid over the student's name, address, license number, and printed respondent's own name, address, and license number. And then item 15, on November 13th, 2013, at approximately 9:30 p.m., respondent delivered the altered certificate to the Department of Commerce and Insurance as an email attachment for the purpose of renewing his license. So we've already concluded those were findings of fact, and so these would tie back to that.
Can we open it up for discussion?
Absolutely, yeah, we can discuss it. You're recognized, Mr. Collinsworth.
I feel like both of these items, 14 and 15, under the conclusions of law, item number 1 would fall under misrepresentation at a minimum for both of these. I don't know.
I have a question, a legal question that I'm wondering about. Is this item 1 and 4, is that stated verbatim out of Tennessee Code annotated, or is that something that was written?
Straight out of the code.
So this is straight out of the code. So this is just outlining what the law is. It may or may not be applicable to every portion of the law, but in this case, your opinion is it's applicable to the misrepresentation portion, not the fraud or dishonesty portion.
Uh,
Or
misrepresentation.
Mr. Chairman,
You're recognized, Commissioner Hall.
I realize that our finding of fact included 14 and 15, that these things did occur. However, I'm concerned about the language that we're looking at here as the proposed conclusions of law, and that says that making a false statement, submitting false information, refusing to provide complete information in response to a question in an application for a license or certification. It appeared to me that he did try to at least tell everybody what was going on. Now, I agree it took a little urging to get to the final bottom line, i.e., yeah, I did photograph this thing. Yes, I did use the whiteout to it. He did attend the class, and to me, the language just sounds a little bit harsh for what we're talking about here. And maybe we're splitting hairs here. Maybe the law is a little bit harder than somebody thinking what they're doing is correct. I know that thinking what is right and what is right are two different things. At least the last time I told a trooper that I didn't think I was going that fast, I didn't get very far. But I'm just a little bit concerned.
Well, and that's why, over and above anything else, I just indicated that I feel like those are both going to fall under the category, because we can sit here and discuss fraud, this and that, all that, but both of those would fall under the category of misrepresentation.
Well, I have no problem with the misrepresentation, but I just don't think I have trouble with saying that he knowingly made a false statement, because I don't think he knowingly made a false statement, because I think he thought he was doing what was right. So I have a little problem with some of the language that is used in here as. I don't know, I'm just concerned.
Commissioner
I want to
Terry,
echo
you're recognized.
what Commissioner Hall said. I think that while there might have been something that wasn't right here, in the respondent's mind, he was not attempting to obtain a license without providing the correct information. It was his understanding that that form was not the correct information. And it seems to me that if we're going to get to dishonesty and fraud, that it really needs to rise to a higher level of attempt to mislead. So I think we can say that, yeah, it was not the right thing to do, but I don't think it was done in a way that was attempting to get around what the proper procedure would be. It may have been a misunderstanding of what that proper procedure would be, and specifically with regard to the form that was turned in the mind of the respondent as I asked him, he believed that was not the document that was necessary. He was awaiting that document that was necessary. All he was trying to do was to demonstrate that he had taken the course and to obtain the document that would be necessary in order to get his renewal.
Oh, and that's the beauty of the word "or," because I'm not saying he was dishonest. I'm not even going to say that he had fraud involved. But I am saying when you white out over someone else's name and put your name, then you're misrepresenting that is your form when it was not your form. And misrepresentation can be one of those items.
I would agree with that. I guess when we get to whether the punishment will fit whatever the misrepresentation is, that's something I would like to come back to.
I think the conclusion of law that's the tie back to even see if there's any disciplinary action or what the punishment will be. And I agree with what you all have said. I don't think we can change what the law says, but if you did strike out the words through any form of fraud or, and just said obtain a license or certificate through misrepresentation, then that might be a linkage, if you were looking for a linkage. Now, that doesn't mean you have to punish somebody severely, but I don't think we can I don't think if you choose to discipline, I think you got to have some conclusion of law or there's no merit to discipline.
If that was the form,
If that's the case.
if that was the form that was intended to be what would qualify for getting the renewal of the license. But again, as I understand it, and from the question that I asked the respondent, that was not what he even thought was the form that would be necessary for getting renewal, just to indicate that he had taken the course that would provide him with the form that he was going to submit for renewal.
I think
Hold on, Mr. Walton hasn't had an opportunity to speak.
the respondent's been an appraiser for 20, 30 years. He's renewed I don't know how many times, and I'm sure he understands you can't renew without proof of your education. So submitting a form that doesn't prove, and meet the state's requirement would be pointless.
But again, as I understand what he said, he did not think this was the form that was necessary to submit, and he was awaiting that form that was necessary to submit. It wasn't that he didn't think he needed to submit a form, or that he even thought that this was the form to submit.
Well, on page 1 of the information submitted by the state. The email directly from Mr. Cameron says, "Hello, I am renewing my appraisal license under CG 426 and wish to send these certificates of completion for classes I have taken for continuing education." So at that point, in my mind, he's saying, these are it. These are my certificates.
Sure. He was showing he had taken the course.
Right.
He wasn't saying this is the document that I need, however, ultimately for meeting the requirements.
Well,
I kind of inferred that from that was it. He wasn't planning
Yeah,
on saying
'cause,
anything else until he was questioned about it.
Well, and here again, given his testimony, he was trying to get in under the wire to save that $100. You've got to renew. You don't say, hey, I want to renew, you renew, or you pay the $100. And I think he was aware of that, and he was trying to get in under the wire. And I think he submitted these false documents in an effort to do that. And I think that's what the evidence shows.
You're recognized, Mr. Hall.
Thank you. This might be a question for the attorney. I know that Mr. Collinsworth has alluded to the word "or," in other words, involving dishonesty, fraud, or misrepresentation. Ability to strike any of that wording, or is that wording have to remain in place?
I think it has to stay there. It's,
You can just
I
find
don't
on,
think you can.
I was just, you know,
Hey,
I have no
Time.
problem.
She's trying to-
we can only speak one person at a time. The court reporter is trying to take this. So.
Okay, Mr. Chick, go on.
I believe the statute, all it's saying is, this is the statute that's identified, and it says this.
So consequently, I reckon what I'm asking is, you do not have to find that you got all three. You don't have to find you got two. All you gotta do is find one. I mean, you can say that you think it was misrepresentation, but it was not dishonesty or fraud that was committed. Is that correct? But the language has to stay in there because that's the law.
Technically, I think you could just say he
actually
violated
strike this and
this
leave it right
statute and
there.
just say the number of the statute, but,
Right. Really, what we're doing is identifying which statute was
We
violated
have 1, 2,
by his actions.
You know, one thing to look at, I mean, we're looking at items, under this, it says items 1 and item 4. So
maybe we can.
there's an item 2 and 3 that was not applicable and was left out. I don't think we can change the wording in item 1 and item 4, but if we so choose to say item 1 may not fit the bill, but item 4 does more so, we could just reference item 4 and leave 1 out, or vice versa.
Well, the statute is the statute,
What is there?
and it does say, again, we're going back to or.
So
Can I ask the judge a question? If we have Tennessee Code annotated 6239326, the state chose only to put items 1 and 4 as areas where the violations occurred. That makes me think that there's probably an item 2 and a 3 that wasn't applicable in this case. Is that correct? So the state pick and choose which ones are applicable.
Well, yes.
So we could further discern that and say, we don't think that there's enough evidence for one of these to be applicable, but we do think the other is. And you still have one state statute to hang your hat on. Is that, I don't know if I'm making sense here.
I think what Chairman Johnstone's proposing to do is to remove item 1 from item 1. So you would only have item 4 remaining.
I'm just throwing that out there. I mean,
And
I'm not-
possibly then it would just say, under the same code, it's just an act or omission involving dishonesty, fraud, or misrepresentation.
And we can't-
And of those
Yeah.
3, we're referring to misrepresentation in this case.
That's,
but it's still applicable.
yeah, and then carrying it on further, we still have item 16,
Right. that will
which
be
relates
next.
to these same two,
Yeah, on the next one.
the same two statutes. In item 16, we had already revised that finding of fact to state misleading response.
Make a proposal?
Yes, sir.
I propose for item 1, under the proposed conclusions of law, that we remove paragraph 1 underneath there, keep paragraph 4 in place, and apply it as a conclusion of law.
Is that a motion?
Yep.
I'll second
Can I
that.
ask a legal question before we get
Discussion.
from the judge? Can we do that legally?
Yes, because what you would do, in my understanding, it would just be the statute 62-39-326(1) without the writing, and then 4. Okay? That's my understanding. You can say yes.
Or
to
would
answer
we
your question.
just remove 1 altogether, where it would just show item 4?
Yeah, you can just do, yeah, right. Sure, you could do that.
Okay.
But that would still, okay.
Still apply to items 14 and 15.
Right, because we're not dealing with
Focusing on
we're not
the
dealing with.
misrepresentation
Right,
of it.
misrepresentation.
Yeah, you can do that.
So, let me understand your motion. Under conclusions of law, you are wanting to say Tennessee Code annotated section 62, 39, 326, item 4.
Correct.
That is our conclusions of law in reference to items 14 and 15 in the findings of fact.
Correct.
Okay. That's your motion?
That's my motion.
That's Mr. Collinsworth's motion. Is there a second?
Second.
Okay, there's a second from Commissioner Walton. Any discussion now?
I have a question. Again, it mentions those 3 things: dishonesty, fraud, and misrepresentation. I realize the statute is worded whatever it says, and we have to go along with that. But is there any statement that this body can make that says that we either do or do not believe all 3 of those things apply in this particular case?
Reference to the misrepresentation under 4. You could sort of, just put that in bold, the misrepresentation.
But we cannot add a statement that would say, and again, I'm speaking for myself, not my fellow commissioners, that we do not believe that there was fraud or dishonesty.
Yes, you could add that statement.
Okay.
Yes.
That could be an amendment to the motion,
Yeah.
because part of the conclusions of law states that your conclusions of law should make appropriate, specific references to the findings of fact to articulate the linkages. So that's what we can certainly amend that motion
Right.
to say that it goes back to that law specific to the misrepresentation portion only. Is that your amendment?
Yes, well, that's my question.
Yeah, you can add that.
I have to remove.
You can accept it, you can accept it as a friendly amendment.
What's the,
I mean,
what is the
friendly.
amendment going to say then?
Well, the amendment is, the amendment, the motion as amended would state that we have motion to conclude, motion to approve as a conclusion of law that the respondent's conduct set forth in findings 14 and 15 constitutes a violation of the following subsections of the Tennessee Code annotated 62-39-326, Section 4, an action or omission involving dishonesty, fraud, or misrepresentation, with our linkage to the findings of fact being misrepresentation only, and not dishonesty or fraud.
That's correct.
That would be the motion as
That's the nature
amended.
of what I was asking.
That's the gist of it. Now, you can, if you accept that as a friendly amendment, then we can move on. If you don't, then we can vote on his amendment and vote it up or down, and then we can vote on the motion.
I'll
as-
accept that as a friendly amendment
Okay, all right.
to my motion. Now,
Second that.
Yeah, you can, so we have the amendment is by Commissioner McCara, seconded by Commissioner Walton, and it is accepted as well by the,
now we have to vote on it.
any other discussion? Does everybody understand what this conclusion of law for item 1 is? Everybody clear?
Yep.
Okay, all in favor signify by saying aye.
Aye.
Any opposed? Okay. Motion approved, as amended, approved. Bear with me, I'm making notes. Okay, item 2, the respondent's conduct as set forth in paragraph 16 constitutes an additional violation of the following subsections of Tennessee Code annotated 62-39-326. Item 1 and 4, which are the same two we just spoke over.
Can I make a motion?
Okay, let's,
And then we'll open for discussion?
okay, let me state one thing. The reference on item 16 is on November 15th, 2013, in response to an inquiry by Commission's Executive Director about the presence of correction fluid on the certificate. The respondent provided a misleading response.
Correct.
Okay, you are recognized, Commissioner Collinsworth.
I move we edit item 2, just as we did for item 1 above. And again, put reference to misrepresentation.
We have a motion to accept item 2 as a conclusion of law, striking section 1 of Tennessee Code annotated 62-39-326 with a specific reference on item 16 under the findings of fact to reference the misrepresentation portion of the code. That's your motion?
Yes.
Second.
Okay, that was Commissioner Collinsworth, seconded by Commissioner Hall. Any discussion? No discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Okay, motion approved. All right, that concludes the conclusions of law portion. Now we're under the disciplinary action side. And our charge is if we decide there has been a violation of state statute or rule, we must then decide what disciplinary action is appropriate in accordance with our legal authority and considering the particular circumstances of this case. We may consider any evidence that the parties have introduced on the issue of the appropriate disciplinary action, including whether the conduct allegedly was or is of a continuing nature or a one-time offense. Additionally, we may also consider what we've done in previous similar cases. Under the law, administrative agencies are not required to have absolute consistency in the disciplinary action they take. However, this does not mean that we may arbitrarily and be capricious in dealing out our disciplinary actions. Disciplinary actions must be fair, must be based on fairness and reason. Okay, as I read through the notice of charges, Causes of action, the state had referenced some civil penalties for the violations, and as at up to $1,000 for each violation on count 1 and count 2. And they also indicated that you could revoke, suspend, or restrict the license as well as the civil penalty. Under the request for relief, you can also assess the charges for investigatory and hearing cost against the respondent. So really, you're looking at, in terms of disciplinary type actions, you've got charges for the violation, suspension, restriction, or revocation, and cost of the hearing and investigatory charges. And this is not mentioned there, but I would believe that there would even be an education component there if you so chose. I'm not saying that we do all of those, I'm just saying those are options that are out there.
Can you make a education, additional education requirement part of the penalty? He brought it up. I was just asking. I didn't know if you could amend that.
I don't know that it's necessary. I was just saying this is everything that's available.
I tell you what, Your Honor, we'll discuss it and
I don't
bring it back up.
As I mention these things, I'm saying these are the options that are out there.
Right.
I'm not advocating one or all of them.
Right.
I'm just saying these are things that can be discussed among us. And personally, I don't know that I believe.
Department has its disciplinary actions.
It
spelled
does
out, right?
actually. There are specific things they can do. One is revoke, suspend. The other is penalties, and the third is cost. So actually, the
Civil penalties. Okay. Okay.
So you're saying that an education requirement? Now, I don't think that that's appropriate in this case, but there are other cases down the road, and I think this would be important for the board to know. Is that something that's an option?
certainly if it's a consent order, if it's an agreed order.
Right.
But, as far as the final order.
All right.
Okay.
Mr. Chairman?
You're recognized, sir.
Thank you. I don't think an education requirement is necessary in this particular matter. I think Mr. Cameron has heard all of us up here make our comments about it. I think most of us up here have tried to understand his position in this matter, and I think we've been very fair in what we've found out and what we've done so far. Like I said about 3 hours ago, this is all over $100. Unfortunately, we've taken up the time of this entire commission, the court, and everybody else in order to get here. I don't think suspension of his license or revocation would be the answer. However, I do feel that a penalty in the amount of $2,000 and pay the investigator and hearing costs, I think he would get the message real quick, like, don't do this again. And so that would be my recommendation.
All right, so
Are we in discussion right now, or is that a motion?
Hold on. Hold. We have a motion on the floor, it has not been seconded. We can discuss it, we can amend it, and so it's not a big deal. If you disagree, you'll have plenty of opportunity.
I'll second the motion so
we
it
have a
can get to the
motion.
floor.
We have a motion from Commissioner Hall to assess a $2,000 penalty, which would be 1,000, is that 1,000 per, for each?
Yes.
1,000 each, and to pay for the investigatory and court cost, and hearing cost. And
I
that's
second the
seconded by
motion.
Commissioner McCara. Any discussion?
Yeah, I've got to say, I mean, I feel like he took the class. He had met the requirement to renew. I think in a panic, he exercised some pretty bad judgment. And it was all over a $100 fee he was trying to avoid. I think you let the punishment fit the crime. I would say a $100 civil penalty plus court and investigatory cost. I think he's got the message. I don't think there's a very big chance that he's going to ever do this again. That's my feeling on it.
That $100, would that be for each count or $50 per count?
Do we have to assess a penalty per each count?
You
If
don't
not,
have-
I would.
It says up to, you don't even have to assess a penalty.
Right. It's my feeling, I think it would just, it would be fitting to assess the $100 penalty. The court costs and investigatory is going to be a few thousand. I would just let it go at that.
Does anybody know have an idea what the court cost and investigatory is actually going to be? Will it be,
Dollars, I would think.
well, a couple thousand or 4,000?
I would think it would be a couple thousand.
Couple
I
thousand?
think typically it's in that $2,000-3,000 range.
Still discussing.
Yes, sir.
I'm in agreement with the motion on board right now. I think something a little more severe than just the $100 penalty needs to be assessed. That's just my.
Chairman?
I recognize, sir.
I think I would support Commissioner Walton's suggestion. I don't think there was an intent to be dishonest in this. And I think we're going to motive as being something that should be relevant to what kind of punishment is involved here. I don't think there was a motive to be dishonest. There was something that was done that wasn't right. But I think that there was no intent to be dishonest, and therefore I think I would support Commissioner Walton's suggestion.
I'd like to comment a little bit further too. I mean, it's just the real punishment here is going to be, this is on his record from now on. It's going to impugn his ability to work in this business. It's going to be something he'll have to disclose. He does a lot of court testimony. I can guarantee you that the other side is going to bring this up. It's going to impair what his earning ability is going to be going forward. So I just, I keep that in mind as well as, cost of E&O. He's going to have some explaining to do every time he renews his errors and omissions insurance going forward.
I would be inclined I think to me, 2,000 or 1,000 each count is probably steep. I do think all the investigatory and hearing costs need to be included in that. But $50 is, that's not, $100, that's, to me, that's maybe a little, that might be a little too light. I don't know. But I don't think it was intentional. I don't think there was ever an intent there.
I see. He made the effort. He took classes, right? Granted, it was at the 11th hour, and that's a lot of what got him in trouble here. But he did take the classes. He wasn't trying to renew using someone else's certificate and hadn't taken the class.
The motion on the floor is for $1,000 per count for a total of $2,000 plus investigatory and hearing cost. If you'd like to amend that on the dollar amount,
Up and down, Mark.
we can vote it up and down, or he can make a motion to amend, either way. Skin the cat either way you want to do it. I'm just trying to, because if you don't like an amendment, you can always vote no. So is that an amendment to?
I say we vote the first motion up or down. That way we just
Okay,
unmuddy
that's
the water.
fine.
We get
That's
clear
fine.
about what we're doing.
All right, we have a motion to, for $1,000 per count, which would be a total of $2,000 civil penalty, with the assessment of investigatory and hearing cost against the respondent. Any other discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed?
No.
No. Can we have a roll call beginning at my left?
Record better.
For the record, beginning with Ms. Point, Commissioner Point.
No.
Yes.
Yes.
No.
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 Okay, the noes have it. Motion did not pass. Floor is still open for any type of motion in reference to disciplinary action.
All right, I'd like to make the motion that we assess a $100 civil penalty and all investigatory and legal cost.
Second.
Is that 100 per count or?
Okay, 100 per.
No, I mean, I'm just asking for clarification.
Clarification, 100 per count.
Okay, we have 100 per count, which would be $200 total, plus all investigatory and hearing cost. Any discussion? If not, roll call from my left, beginning with Commissioner Point.
No.
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 Yes.
No.
Yes.
The noes have it. Still no motion, still no disciplinary action has been approved at this time. Floor is still open for discussion or motions.
I would like to make a motion that we assess the court costs and $500 total for the two counts, $250 each.
Okay. We have a motion for a $200 per count or $500 total.
$250,
Oh,
$500 total.
I'm sorry. $250 or per count for a total of $500 plus investigatory and hearing cost. That's Commissioner Point. Is there a second for discussion?
I'll second that.
We have a second by Commissioner Collinsworth. Any discussion? As long as before we vote this up or down, why don't we just decide, is everybody happy with, what do you want to see the dollar amount be? Obviously, we know there's a $2,000 and then there's a $50. So there's a big spread.
Like all appraisers, we got a good range here.
I say we vote it and see what we got.
Yeah. All right.
Pretty close.
I think we're getting closer, but anyway, we'll see. All right, proceeding from my left with Commissioner Point, please vote.
Yes.
No.
Yes.
Pass.
Yes.
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 Put me as a yes. The yeses have it. All right, so under the disciplinary action, we have determined that there'll be a $250 civil penalty per count for a total of $500, plus the assessment of investigatory and hearing cost against the respondent. Getting there. So that concludes item 3. Our last component is item 4, which is a policy reason. And I'll read this statement, and we can determine whether or not we agree that this is an adequate policy reason. The Tennessee Real Estate Appraisal Commission is charged with the duty to regulate the practice of real estate appraising in the state of Tennessee, such that the citizens of this state receive all such services in accordance with the state law and regulations. Because the respondent has violated this law and regulations governing the practice of real estate appraising, it is in the public interest of the citizens of this state and for the protection of their welfare that we have assessed the civil penalties of $250 per count, plus the assessment of investigatory and hearing costs to the respondent, Mr. Roger E. Cameron, period.
So moved.
The policy statement has been moved by Commissioner Walton. Is there a second?
Second.
Seconded by Commissioner Hall. Is there any discussion on the policy statement? Or policy reason, excuse me. If not, all in favor signify by saying aye.
Aye.
Any opposed? Okay, Judge Ball, I think we've done our 4 items, and we turn it back over to you.
Well, this has been interesting, but this does conclude this matter, okay? And thank you all. Thank you, Mr. Cannon.
Formal hearing is now adjourned, and we'll continue with the remainder of business of this board.
Next item on the agenda was the education report, if Dr. McCara is ready.
Okay.
All right, Dr. McCary, you are recognized, sir.
Okay, if I can find where my notes are here. Had good the ones on here. Okay, we had 1, 2, 3, 4, 5, 6, 7, 8, 9 applications. 8 of these were for continuing education. 1 was for qualifying education, and 1 was for both qualifying and continuing education. I recommend approval of the continuing education courses, the 2 from the American Society of Appraisers, the 3 from the ASF MRA, the independent, the 1 for, presented by Brian Reynolds. And I also recommend approval of the qualifying education individual course for Herbert R. White. The 2 courses from the NAIFA do not have complete documentation at this point, and I would recommend that they be approved contingent upon receiving full documentation.
Okay, you've heard the report of the Education Committee with the recommendation from Commissioner McCara. Does the chair hear a motion to adopt the recommendation?
I so move.
That recommendation has been moved by Commissioner Point. Is there a second?
I'll second it, then I have a question.
Okay, we have
for
a
Dr.
second by Commissioner Hall. Now we are ready for discussion. Commissioner Hall, you are recognized, sir.
Quick question. The qualifying education that you approved, was that the application and case studies 900 course?
Which one are you referring to, sir,
It's
by
the
number?
one that, 1780.
1780?
Was that's what the course number, then over here you got application and case studies 900. And I'm just wondering, is that the one that you approved for the qualifying education, or what one? You got a CE and QE both in here.
Yes, sir.
And I'm just trying to get which one is which.
I approved both of them. That's why I put the approved in between the QE and the CE to indicate that for both. That's being approved for both qualifying education and continuing education.
Gotcha. Okay. Thank you.
I apologize for the confusion.
No
in the
problem.
future, I'll put the approved next to each of them. Thank you.
Is there any further discussion on this motion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Okay, the education is approved. We're now ready for the director's report, and you are recognized, Ms. Nicole. It's been a long day.
You made me snort. All right.
Sorry for the informality there. Director Avers, you are recognized.
The director's report is on your iPads. first item on there is the Association of Appraiser Regulatory Officials, ARO, meeting will be held in Washington, D.C., October 17th through 20th, 2014. I recommend the commission send 2 of its board members, the executive director and the litigation attorney, to the conference. This conference is going to be very critical in the preparation for upcoming implementation of the fingerprint background check requirements. We get the federal updates from the appraisal subcommittee and the foundation at this meeting. And there's going to be a lot of presentations on appraisal management companies. In 2016, maybe 2017, depending on when the federal rules get implemented, all states are going to have to be regulating appraisal management companies. Currently, Tennessee does, but by 2016-17, depending on that implementation date, we're going to have to meet the federal requirements. So it would be advantageous if we could send our AMC member to ARO to attend this conference so that he can help us with any rules we may need to adjust for 2016-17. And I need a commission vote for travel recommendations.
Okay, you've heard the director's report. On the travel recommendations, how many will that be? Is that 4 total or 3 total?
4 people total.
2 members and
Me,
and
Adrian Chick, he hasn't attended one of the ARO conferences yet, so we've asked him if he would attend. I'd recommend that Mr. Collinsworth go if he's available, and then one of the other commission members, if you want to designate someone, the chair, or maybe the education member, or whomever you all choose as your representative.
Do we decide that today, or are we just approving the travel?
Yeah, you need to decide, because I need to start entering travel requests pretty soon. It's a Friday through a Tuesday, well, Monday, but probably wouldn't be able to fly home till Tuesday.
Oh,
Yeah.
I'd like to, Ms. Johnstone, let's make a recommendation that we vote for sending 4 individuals to the conference, which will be our executive director, our litigation attorney, also Mr. Collinsworth, and the chairman of the commission. If he is not available, then he can select someone of his choosing.
You've heard the motion. Is there a second?
Second.
Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Okay, motion approved.
And just in case you need to know, I am available at that point in time. I already know.
AQB meeting, is that?
The AQB meeting is going to be September 19th. Because of all the rulemaking hearing stuff we have coming up, I wasn't able to coordinate it with our board meeting to be in Memphis. So I'm going to do a travel request for me to attend, and I'd like to get that request for the board attorney to attend also. I'm hoping that 1 or 2 of the board members would volunteer to attend. It is going to be in Memphis, so I was hoping it wouldn't be too hard for Mr. Walton to attend.
That's not too hard for me to get there. So I may try to see if I can.
I couldn't get, maybe the whole board could go, but if we can have a showing of if anyone's available to attend the AQB meeting, it would be really great if we could make a presence at the AQB meeting.
If I may make a comment here, I noticed that Mr. Johnstone lives in Jackson and Mr. Walton lives down there in Memphis. To me, they'd be the 2 logical ones to attend, and because one is chairman there, one will be chairman coming in, and so I think that those 2 individuals would be the logical choices, and I recommend that we approve this.
Let me say, I'm scheduled to work on the fire department 24 hours that day.
All right.
So
Anyone else want to go? Everyone's just loving to see the AQB.
Hey, but Rosie, you want to go down?
You're close.
I can try to get us travel approval. I could get your travel expenses reimbursed, it might help, but. It is
I
kind-
should be able to do September 19th.
All right, let me see what I can do. You want me to try, Mr. Walton?
Or just getting me registered?
Or there's no cost to register, so if you want to go, just go.
Yeah, we can leave it at that.
Okay.
'Cause I'll have to make arrangements to see if I can get off.
Okay, so if you just happen to get the, pop over. All right.
Let me know where you're sitting.
Where is this meeting? Do we know what's going to be held?
We do. I didn't print the flyer out, but I'll email it to everybody so that everyone has the opportunity. If you just happen to have that day free, it's Memphis. I'll buy the barbecue. There's a great place down by the river.
Only open during May.
Could I get a motion on that for entering travel approval just for the few individuals I'm going to do a request on?
I made a motion to that
Austin
effect.
Hall?
Yes.
I'll second that.
That's
Okay.
for the two board members, myself and Commissioner
us.
Johnson, and Walton, possibly, and/or,
Okay,
and the executive
guest.
director and the board attorney.
okay.
Is there a second? Commissioner Hall
I
made the
seconded
motion,
it.
seconded
Yeah, I
by
seconded.
Commissioner Cosworth. Any discussion? Not all in favor signify by saying aye.
Aye.
Any opposed? Motion approved. Okay, 2012 rules update.
Good news, the 2012 rules have posted. We've gone through GovOps. They said thumbs up, and it is going to be a thing this month. Effective August 21st, we will have new rules. Yay!
Awesome.
Yay!
They're out
And
of date
keep-
now.
Item 4, I'm going to let Keeling give you the update on the 2015 rules, because I get to give him the rules and she gets to give the... Yeah. On the record.
Well, I've done everything I can to prepare the new rules. They have been sent to the Attorney General's office for can't set the notice of rulemaking until after we get those rules back from the Attorney General, because they kind of do a once-over to make sure everything is as it should be. Those have been submitted as of, I think it was the end of June, maybe June 26th. I have not received those back yet, but they are promising me, well, last week, actually. I didn't get those last week. So it's the first thing I'm going to do when I go back upstairs is check on those, because if we don't hurry, we're going to have to do emergency rules, and that's just going to cause even greater. But the good news is we are on schedule, so we're doing everything we can. I'm sorry, that's not very exciting, but it is what it is, I guess.
Thank you for that fantastic update on the 2014-15 rules.
So entertaining and delightful.
Is there any, under item of new business, is there any new business? If none, do I hear a motion to adjourn?
Excuse me,
Is
a
it
question
under new
for the
business?
newcomer on the committee here. What are we supposed to do with all this documentation? Are we expected to destroy it or keep it for our
You're
records?
supposed to keep for 5 years.
For 5 years? Okay.
2 years
Now,
past.
come on, don't play games with me,
Don't you-
Commissioner.
can't
I
we
need to
leave
know
it
what
right
to
here
do
and
with this.
Dennis
I'm
will
trying to
destroy
follow
it?
the rules here.
There's a pop test.
Okay, thank you. Okay.
Office
Thank you.
Depot, professional grade shredder,
That's right.
right.
Something like
$499.95.
that.
Is there any other new
Expensive.
business? If not, do I hear a motion to adjourn?
So move.
Second.
Commissioner Hall, seconded by Commissioner Collinsworth. Any discussion? If not, all in favor signify by saying aye.
Aye.
We stand adjourned.
About time.
I like this big one. The one I have in Madison County, it's small, so I gotta really hit it hard. This one, you just,
When your year's up, you can just take it with you. We'll get a new
hey,
one.
if I showed up Monday with this